Good afternoon, everyone. Welcome to the February 27th, 2025 meeting of the Town of Chatham Zoning Board of Appeals, pursuant to Governor Healy's March 29th, 2023 signing of the Acts of 23 extending certain COVID measures adopted during the state of emergency, suspending certain provisions of the open meeting law. This meeting of the Chatham Zoning Board of Appeals is being conducted in person and via remote participation. Every effort will be made to ensure that the public can adequately access the proceedings provided for in the order. A reminder, those who'd like to listen to the meeting while in progress, please call 508-945-4410, conference ID 448-643-014 or join the meetings through the link in the posted agenda. This is a live broadcast and simulcast, but despite our best efforts, we may not be able to provide for real-time access. We'll post a record of this meeting in the town's website as soon as possible. In accordance with town policy, the public can speak to any issue or business item on the agenda during the meeting when recognized by the chair. First thing we do is we do a roll call of all board members. We ask if any citizens or non-board members participating in the call just identify themselves with 4 digits of their phone number. The hearing notice is read by our staff, Sarah Clark on my right. You or your representative will provide the appeal, and then anyone in favor of the appeal can speak up to 5 minutes. I will read any correspondences that we have, and then those who are want to speak against the appeal can have time to do that. And if you have sent a letter, I'm going to sort of take attendance to see if you'd rather have your letter read or if you'd like to speak in person. So you'd have to pick one or the other. Anyone against, like I said, will be able to speak for up to 5 minutes. The applicant can rebut any testimony. Then members can direct questions to anyone present. The board hears further information, deliberates, we close the public hearing, that's when we deliberate, and then we usually vote on the appeal or application. All votes are taken by roll call, and at the end of the meeting, we'll close via verbal confirmation and note of the time of adjournment. So, as I said, the first thing we will do is take a roll call of all board members and just to confirm that they agree with this form of meeting, starting with this end of the room.
David H. Veach, and I approve this form of meeting.
Ed Acton, I approve.
David S. Nixon, I approve.
Paul C. Semple, I approve.
Lee Hovey, I approve.
Stephen D. DeBoer, I approve.
Virginia Fenwick, I approve.
And Randy Potash, I approve as well. Next, we're going to have meeting minutes, Paul, January 23rd, 2025.
I'll move to approve the minutes as amended for January 23rd, 2025.
Dave Veach seconds and votes yes.
Let me just make sure, is there anybody that has any other changes? No? Okay, and you vote yes?
And I vote yes. Yeah.
David?
I vote yes.
All votes yes.
Ginny votes yes.
As do I. All right, that's unanimous. First application, 107 Sequansit Road. No, did I miss something? 359. Oh, I'm sorry. Oh, we're going to do 359 first. I apologize. 359 Main Street, Noble House Hotels. And this is 24-129, and Sarah will read the advertisement. All three.
Application number 24-129, Noble House Hotels, care of Sarah Toronto Flores, Esquire, 155 Seaport Boulevard, Boston, Mass. 02210. Operator of the property located at 359 Main Street, also shown on the Town of Chatham's Assessor's Map 16C, Block 83, Lot 67. The applicants are appealing the building commissioner's determination that variances are required for the increase in rentable rooms as well as the increase in building height as aggrieved parties under Mass General Law, Chapter 40A, Section 8, and Section 8D2A of the Chatham Protective Bylaw. Under application number 24-130, the applicant seeks dimensional variances from the buildable upland area requirements for 6 additional rental units and the increase in building height above the 30-foot maximum allowed. A dimensional variance is required under Mass General Law, Chapter 40A, Section 10, and Section 8D2C of the Chatham Protective Bylaw. Under application number 24-131, the applicant proposes to change, alter, or expand a non-conforming hotel/restaurant on a non-conforming lot via the construction of additions. The existing structure is non-conforming in that it is located 21.9 feet from the road where a 50-foot setback is required. The structure contains 18 rental rooms plus manager's quarters on a lot containing 37,281 square feet of buildable upland, where 64,000 square feet is required. The proposed 6 rental rooms require an additional 18,000 square feet of buildable upland area. The existing lot coverage is 20,214 square feet, 48.32%, and the proposed lot coverage is 20,348 square feet, 48.64%, where 90% is the maximum allowed. The lot contains 41,831 square feet in the GB1 and R20 zoning districts. A special permit is required under Mass General Law, Chapter 40A, Section 6, and Section 5B of the Protected Bylaw. This was continued from December 19th, 2024.
Frontage, not an issue, was incorrect.
Okay, so council,
Madam Chair, Bill Riley, on behalf of 359 Main Street, Chatham Inn.
welcome.
Thank you. I'm with Liza Cox, who is a partner at Letter McLennan, along with Sarah Toronto Flores. Sarah, unfortunately, has left us for the judicial bench in the land court. She was just confirmed by the Governor's Council yesterday, unanimously.
And congratulations to
happy.
her. We're honored to have been in her presence.
Yeah, well, she's going to be a great judge in the land court. In any event, her partner, Liza Cox, is with me here. Oh,
Great.
yeah. Maybe someday the camera will show her as well.
No, we see
Thank
her.
you.
We see her smiling
Okay.
face.
Okay, great.
Super. Thank you. Good afternoon, Madam Chair, members of the board. As Bill said, my name is Eliza Cox, and I'm an attorney at Nutter, McLennan and Fish, and pleased to be here with you this afternoon. As the board will recall, this matter was initially heard on December 19th, where Sarah and Bill presented the testimony to you, which together with the supporting materials that we provided throughout the course of these applications demonstrated, number one, why we believe this project is eligible for a special permit under Section 5B of your bylaw. Number two, how this project meets the special permit criteria. And three, in the alternative, and although we strongly contend it is not necessary, we also demonstrated how the project meets the applicable variance criteria. At the December 19th hearing, the board voted to continue the hearing today, primarily for two things. First was to provide an opportunity for dialogue between my firm and town council regarding our legal analysis as to why the project only requires a special permit and not a variance. And number two, at the same time, in response to comments that were made at the initial hearing, to provide our project team an opportunity to evaluate whether the proposed elevator shaft could be reduced in height. As to the first reason for the continuance, following that December 19th hearing, Sarah from my office reached out to town council to try to set up a time for us to discuss our respective positions. Unfortunately, other than an email that we received from town council dated January 8th, suggesting that Sarah put our position in writing, which she did on January 15th, we haven't heard a response, although I do see town council is present this afternoon, so I imagine we will hear from him today. As part of the February 6, 2025 supplemental materials that my firm submitted to the board, we also enclosed the relevant provisions from that January 15th email to town council, again, setting forth our position in essentially 16 numbered paragraphs. Hopefully you've all have had a chance to review it, and those, of course, detail why we believe this project only necessitates a special permit and not a variance. But essentially, those 16 paragraphs boil down to the following legal principles that I wanted to just briefly highlight as it relates to this application. First, in the first two paragraphs of the email, numbered paragraphs 1 and 2, we discuss the Rockwood case. In paragraphs 3 through 5 of the email, we set forth how the law is clear that a municipality is free to adopt a zoning bylaw that is more liberal than the Zoning Act, and how in reviewing zoning appeals, Massachusetts courts instruct us to look first as to whether the local bylaw is more liberal than the state zoning act. The email also addresses the Harrison decision. Specifically, the Harrison decision does not constitute a blanket ruling that Chatham's bylaw is never more permissive than the Zoning Act. Rather, Harrison is a very fact-specific holding, which concludes that the project that was proposed in Harrison, which is entirely different than what is being proposed in these applications by Chatham Inn, did not qualify for a special permit under Section 5B of your bylaw or under the Zoning Act. That, again, very fact-specific holding in Harrison says that 5B of the Chatham zoning bylaw does not authorize the grant of a special permit approving a reconstructed non-conforming structure that does not reside on the original footprint but resides elsewhere on the lot. Again, that is very different than the applications that are before you this afternoon on behalf of the inn. As the board will recall, in Harrison, the project involved demolishing a pre-existing non-conforming structure, reconstructing a new structure, also non-conforming, in a different place on the lot, and at the same time creating new dimensional nonconformities. And that's all contained in paragraphs 6 through 9 of the email that we submitted. We also explained in paragraphs 11 through 16 of the email how Chatham Inn's proposal is, again, nothing like Harrison, and how it falls clearly within the provisions of Section 5B of the bylaw, which authorizes extensions, including those involving increases and enlargements in commercial non-conforming structures and uses by special permit. And that's contained again in paragraph 11 through 16 of the email that was submitted. And so as you deliberate on appeal number 24-129, which is the appeal of the building commissioner's decision, I urge you to look back at the email that we submitted and those 16 numbered paragraphs, which concisely detail our legal analysis as to why this project only requires a special permit. As to the second reason for the continuance, following the initial hearing, we went back to the project team and asked them to revise the elevator and the shaft to only access the first 2 floors, as was suggested for us to consider at the initial hearing. However, during this investigation, our project team discovered that the rooms on the first 2 floors of the inn could not be made ADA accessible because the hallways on those 2 floors did not provide adequate width to meet the accessibility requirements. Therefore, we went back to the original plan to have the elevator service all 3 floors so that we could provide for ADA compliant rooms on the 3rd floor. However, the client also asked the project team to evaluate whether the elevator shaft could be reduced in height so that it's the lowest possible height. And Sarah, if you're able to pull up sheet A5 of the plans that we submitted, thank you. So this plan was submitted with our February 6 memorandum and shows the revisions to the elevator shaft. Now, as proposed, it only extends 18 inches above the roof line. As you can see, the ornamental design has been maintained with the revised drawings. I know at the initial hearing, there was a question as to how does the elevator shaft compare with the chimney on the building. And with this revised design, it is now lower than the chimney. Also, if you look at this sheet, you can see how minimally visible the elevator shaft is. So the top view, where it says view from the north, that's along Main Street, and the perspective that top drawing is giving is as if someone is standing on the other side of Main Street from the inn. And as you can see, you cannot even see the elevator shaft from Main Street. So I would submit that to the extent that the elevator shaft is even subject to the bylaws building height requirements, which we question, there is no substantial detriment associated with this minor increase in the pre-existing nonconformity of the height of the building. And not only is there no substantial detriment, I would suggest there's a benefit associated with this because it provides for improved ADA and accessible access throughout the structure.
Can I say something?
Please do.
Also, I noticed that on the revised site plan, Sarah, if you can put that up. Right. He shows the proposed condition plan, all right. The actual height of the building, the ridge height, is already over 30 feet. Not by much, but by a little. And so the ridge height's already non-conforming, and I don't think we're talking about a variance for the elevator shaft. See, so he puts the elevator roof at height 33 feet, but it's only 18 inches above the ridge. So that puts the ridge slightly over 30 feet. Just something I noticed and I wanted to bring it to your attention.
Right, so we are of the position that by special permit under section 5B, again, to the extent that the elevator shaft is considered part of a building height, that the non-conforming condition with the ridgeline already exceeding the maximum allowable height, the increase associated with the elevator shaft can also be permitted by special permit. Again, assuming, which we question, whether it is subject to the building height requirements.
It's right here.
Yeah. One additional consideration I wanted to mention on the variance application, should you need to get there, is that in addition to the arguments that we made at the December 19th hearing and in the filings that we submitted, I would also just note that this is a highly unique structure, and a unique structure is one of the variance prongs set forth in both your bylaw and 40A. It is historic. It's one of the oldest, I think the oldest inn on Cape Cod. And as currently configured, a literal enforcement of the bylaw would result in substantial hardship, financial or otherwise, as the inn cannot provide ADA accessible rooms without either reconstructing the hallways on the first and second floor, which would be a tremendous expense and likely result in the reduction of the number of rooms, again, another significant hardship. And so the requested relief to have these additional 6 rooms with the elevator, we suggest may be granted without substantial detriment or derogation. The elevator, again, is a tremendous benefit. It has a negligible impact in terms of its visibility, as you saw from the perspective that was just being shown. And of the 6 new rooms, 2 of them will be ADA compliant, again, within the existing footprint, all of which, as Sarah went through at the last meeting, and as shown on the slides that were presented at the last hearing, have no substantial detriment, and in fact, I would suggest are a benefit to this project and to the town. So I think I'm going to pause there. I don't know, Bill, if you have anything else to add. Otherwise, we'd want to respond to any questions or comments that come up.
Yeah, only that the fact that the building current ridge exceeds 30 feet is in that block of calculations that were in the upper right-hand corner of the site plan. See, so he lists subject, lot coverage, site coverage, the last line, building height, 59.97, required, 58.04. So we're already almost 2 feet above the 30-foot minimum or maximum. So that was my basis for that.
Okay,
That's all we have. for
is
the
that your
time.
presentation?
Yeah.
Okay, very good, very good. Stand by. Is there anybody here on Microsoft Teams that wishes to speak in favor of this application? Please raise your hand.
Yeah,
People
good
are
job.
here, they're not
Good
raising
job
their
on the
hands.
hardship.
I don't know if there's anyone on Microsoft Teams in favor. No, there is not. Okay, so now I will read the one letter that we got from the Chatham Old Village Association, February 24th, 2025. The Board of Directors from the Old Village Association has met to discuss this application by the Noble House Hotels. Our mission is to protect the architectural integrity of the many varied buildings in the neighborhood extending from Homestead Lane along Main Street to Bridge Street. Although not in the National Register, the Inn is an iconic structure serving as a gateway to our historic village. Regarding the applicant's request for a variance, the substantial hardship criteria does not apply in this situation. The explanation that the applicant spent $13 million on an assumption that ZBA would not be literally enforced is, ZBL, it says, is clearly a lack of due diligence on the applicant's part and constitutes a self-imposed hardship. The ZBA should support our experienced town council's opinion that a variance is required and it should be denied. Special permits may be granted if the visual characteristics are minimally impacted, including views and vistas. The plans to create a third story containing 6 additional bedrooms and bathrooms, as well as a structure necessary for an elevator on the roof, are alarming and not in keeping with the historical nature of the inn. The streetscape will change dramatically, not only from Main Street, but from Homestead Lane, School Street, Sunset Lane, and Chase Street. The architectural landscape will be dramatically altered, and the proposed alterations will negatively affect the aesthetic harmony of our historic neighborhood. For these reasons, on behalf of the OVA Board of Directors, I request you deny the variance and special permit. Thank you for your attention to this matter. Winnie Lair, President of the Old Chatham Village. That concludes our correspondences by people in the community. Now, is there anybody here or in Microsoft Teams that wishes to speak against this application? If so, please raise your hand. I don't see any citizens, but I know we have town council. And we will call on town council. Welcome, sir.
Thank you very much. Jay Taylorman, Town Council, pleased to be here. Eliza, please pass along my congratulations to Sarah. We've been friends for a long time. That's great news. I can't wait to appear before her. So this issue, in terms of a legal opinion from council, started with prior council. We've reviewed it. We've reviewed Sarah's opinions. We've reviewed the correspondence from Bill as well. Obviously, I was here when Eliza was just talking about reiterating Sarah's points. So we disagree. We understand the argument and the reasons they're making, but I think that, and I'll explain kind of how we get here, but basically they're focusing on the wrong component of the Harrison decision. But let me explain a little bit as to the landscape in and around this kind of area of law, because it can be somewhat tortured under Chapter 48, Section 6, when we're dealing with pre-existing non-conforming structures. And there are different standards as well for single and two-family structures, as well as versus commercial structures or non-single and two-family structures, which is what we have here. For single and two-family structures, under a long line of cases, this project, which involves, among other things, 2 expansions of pre-existing nonconformities, would require just a special permit. The law is a little bit different as it applies to commercial structures. They don't get the same favorable treatment that single and two-family structures have. And that is that under a number of cases, including the Rockwood case that is explained in your papers and discussed by both myself in my email opinion that I supplied several months ago, and in Nutter's opinion as well, the Rockwood case states the following, and it tracks the statute. It states that essentially, if you have a non-conforming commercial structure and you are going to change it in some way, but not increase that nonconformity, then you need just a special permit. If you are going to increase that nonconformity, you need a variance. It's much more black and white in terms of that nexus than with single or two-family structures. So again, for illustration purposes, if I had a commercial structure that was non-conforming because of a side yard setback, and I want to do a change on the other side of the building that was conforming, and the change itself was conforming, then that would just be a special permit, because I am making a change to a pre-existing non-conforming commercial structure, but I'm not intensifying that non-conformity. If, on the other hand, on the side setback where it was non-conforming, I was intensifying that non-conformity a lot or a little, then I would have to get a variance. And that is essentially what the Rockwood case says. However, as counsel for the applicant has pointed out, a town is free to kind of liberalize their particular provisions regarding pre-existing non-conformings, and they are allowed to provide more benefits. Those benefits, and they could be very expansive. In fact, one was mentioned previously with respect to your variance procedures, where you allow slightly more categories of hardship to be presented. But as it applies to single or two-family structures and commercial structures, you have the right to make it easier for an applicant. You can't make it harder, but you have the right to make it easier for an applicant to gain relief and essentially eliminate the requirement for a variance. So what has been the focus of this matter is Section 5B, which states the key language here. It says, other pre-existing non-conforming structures or uses may be extended, altered, or changed in use by special permit, provided the Zoning Board of Appeals finds that such extension, alteration, or change will not be substantially more detrimental to the neighborhood than the existing non-conforming structure or use. That is roughly tracking the language of Chapter 48, Section 6. That language is also substantially similar to the language that was at issue in the Rockwood case. In other words, it is not particularly liberalizing or making it easier for an applicant. Let me just kind of break it down so that we know exactly what we're talking about here. This language essentially states what the statute already states, that if you are going to change a pre-existing non-conforming commercial structure, then you need a special permit. This language is silent on whether or not you are intensifying that particular commercial structure. It doesn't state anything about it. It doesn't liberalize the practice at all. And that's exactly what the court ended up with in the Harrison case in the last few paragraphs. Yes, that case did involve a reconstruction as opposed to a mere change, but ultimately the conclusion that they reached was buffeted by the fact that it was essentially the same exact kind of bylaw as was in play in the Rockwood case. So essentially, the Chatham bylaws is the status quo as what exists under the statute. And that is that if you are just changing a pre-existing non-conforming commercial structure, but you're not intensifying the non-conformity in any way, shape, or form, and the change conforms with zoning, then all you need is a special permit. But if you are intensifying, and this is the Rockwood decision, and it is the Harrison decision, then you need a variance. And there's nothing about your bylaw that puts it in different footing than the situation in Rockwood, and in my opinion, in Harrison as well, notwithstanding a slightly different fact pattern. So as to whether or not it meets the variance criteria, that's not something I've looked at. I'd be happy to provide some guidance on that, but my focus has been on this issue, and I agree with former town council on this and the building commissioner, and feel that that decision should be upheld and a variance should be required. And I'm happy to take questions from the board.
Thank you, counsel. Would you like an opportunity to rebut, counsel for the applicant, and also rebut the letter that I read?
Yes, we would.
Please go ahead.
Yeah. So first, as it relates to the letter, I would just again remind the board that this project was before the HBDC, which issued a certificate of appropriateness focusing on the visual impact of any change. And that board did find that the changes were appropriate for the district.
And the applicant made changes at the request of the Historic Business District Committee.
Secondly, as it relates to town council's comments, I agree, I think, with the initial part of his comments where he was characterizing Rockwood, and I also agree with him that the courts have recognized that towns can create more liberal bylaws that can provide for additional permissions beyond what 48(6) allows. Where I think we disagree is whether that has happened here in Chatham. The Harrison case is focused on the question of reconstruction and whether the Chatham bylaw authorizes a pre-existing non-conforming commercial structure to be reconstructed, and it does not. There is not language in the Chatham bylaw relating to reconstruction. This, though, is very different than the situation in Harrison. And when I look at the zoning bylaw, section 5, I think it is distinct from the generic language that's contained in 40A. It specifically, even the section 5B allows for the enlargement. That word is in there. That's not in 40A. That talks about the enlargement, extension, or change of a non-conforming use. Similarly, when you look at section 5B, one of the criteria, number 3, is the extent of a proposed increase in the non-conforming nature of the structure or use. The only way that makes sense is if the board is authorized to allow by special permit non-conformities to be increased. Otherwise, has no meaning, and that can't be the correct reading of that language. So I suggest, as we have indicated in the memorandums and emails that we've submitted, that frankly, Harrison is not applicable here. Harrison related to reconstruction, which is not what's proposed, and that this type of extension of an enlargement of a pre-existing non-conforming structure by special permit is squarely contemplated by section 5B of your bylaw. Bill, I don't know if you have anything else to add.
Well, and of course, we have the history in which we have done this. The zoning board has done this many times. And so I think that for the town, with essentially no conforming commercial buildings, or very few, that to require a variance for every minor change is going to make things really difficult. So from a policy point of view, I think a good decision would be to recognize the difference between section 5B and section 48, chapter 48, section 6. As Eliza pointed out, it allows enlargement, it anticipates enlargement. And so I think the generous-hearted town meeting in Chatham that voted that language intended it to be used in a generous manner. Thank you.
Thank you. Okay, so anything else from council on that? But we'll get
Yeah,
back to you for questions, but please go ahead. And,
Right, the question isn't whether or not an enlargement may be allowed by special permit. I would agree that an enlargement would be allowed by special permit, provided that enlargement doesn't intensify a nonconformity. That puts it in a different category. Again, using the example that I mentioned previously, where you have a right side setback, you could have a substantially large enlargement on the left side of the building that conforms with the bylaw with that left side setback, and that would just be a special permit. So this isn't about an enlargement. This is about increasing a nonconformity, and that's what we have here. And again, the bylaw is the same bylaw that was essentially at issue in Rockwood, and I think the same conclusion has to be reached.
Okay, thank you.
Madam Chair, if I could just, again, in response to that, refer the board back to
Okay,
5B3, which says one of the factors the board looks at in granting or considering a special permit is the extent of proposed increase in non-conforming nature of the structure or use. To me, that clearly says that the board has the authority under this bylaw to allow for an increase in the non-conforming nature of the structure or use. It's something that the board considers when contemplating the special permit.
And also, when you compare that, when you take that language and combine it with the fact that the word enlargement appears in the beginning of section 5B, it's clear, well, we think it's clear that, that the kind of proposals that the inn is making are clearly within the special permit bylaw.
Counsel, do
Thank
you
you.
want to rebut that, or should we that,
Yeah,
I can
no,
ask you that
I-
later if you want.
No, I get the argument, but the judge in the Harrison court actually noted that there were criteria below that language and said it was of no consequence. So it's already been that's already been considered. I understand. It certainly is kind of indelicately put, but the principal components of Section 5B still, I think, are the controlling components here. And so that I believe that the building commissioner was correct in that a variance is still required.
Okay, so now we're going to go to questions from the board, I think. And so if counsel can stand by. David Veach, questions? And this is, I think the first issue we're on is whether or not to deny the appeal of the board, of the building commissioner.
Right. Let me try to I have questions, and I'm not sure I can get to all of them, but I've
He's a good
spent
guy.
quite a bit of time reading these cases, and I guess the first thing I would like to say is the more I read court cases, the more I appreciate attorneys, judges, members of the bar. I appreciate there are people who do this and do this for a living in order to help us, those of us who don't do this for a living. And I guess the other thing, I mean, just to preface my questioning, as the owner of commercial property in Chatham, I remember when the Harrison decision came back, feeling pretty disheartened in many respects. To think that the distinction made, although I didn't understand that the town could pass less restrictive zoning. So it seems to me that the disagreement among the attorneys, it comes down to whether Chatham has written its bylaw in such a way as to be less restrictive than the interpretations of 40A Section 6, court interpretations, because from what I can see of this, the whole history of it is what's the word, infelicitous language that some court brought up to talk about the conundrum, I guess you call it, that the legislature has put before the courts with respect to interpreting this section of the bylaw. And I'm somewhat inclined to listen to this because it sort of gives me a little bit of hope that the attorneys for the inn have made the presentation. Well, maybe there's some daylight here with respect to use of things. But so, and it seems very much to me that I see the words, and I'm a layman, so I see the words extension, enlargement in Chatham's bylaw. I also see, Jay, I hear this brings the word intensify to it. So now we're talking about intensify versus extensify. So Jay, one question would be, talk to me about that wording. Is that intensification? And we've heard that also with respect to other court cases and things. Is this something that the courts in case law have introduced into all of this?
Well, I think it's partly the statute and partly the way the courts have dealt with that. Most of the traffic, so to speak, in the courts around Chapter 48, Section 6 has been in and around the slightly more difficult procedures in and around regulation of pre-existing non-conforming single and two-family structures. Following the Rockwood case, there really hasn't been a substantial body of law in terms of changes of the way the courts have seen it with respect to commercial structures, because the statute doesn't specifically provide more protection, and because the Rockwood case set up something that was a little bit more binary than than all of the various cases regarding single and two-family structures. I think what it comes down to at the end of the day, when analyzing the Rockwood case and thinking about it in terms of your own bylaw, is that if you can enlarge all you want. If you have any nonconformity on a structure, a commercial structure, it is a nonconforming structure, period. And you are going to need some relief if you are changing that structure.
Right.
If you are changing it so that the nonconformity gets worse, you can call it intensify or increase or whatever, but if it gets worse, more, closer to the lot line, taller than an already non-conforming height, then you would need a variance. If you are going to change something else about the structure so that it doesn't get worse, then you need just a special permit. In a lot of cases, Dave, what we see is situations where we have just an undersized lot and the setbacks are just fine, and additions to these structures are fine. It's just an undersized lot. They're just moving things around. There's no new setback violation, no new height violation or anything. And those are the kinds of situations where we see a lot of special permits for commercial structures. But where there's already a different, more dimensional nonconformity that someone is increasing here, the upland requirement and the height requirement with respect to the elevator shaft, you are making those nonconformities, those specific nonconformities, worse. Now, I don't like putting the term worse on it because people might be totally satisfied with it, but you are making it more nonconforming than it already is. That's a variance under the Rockwood case. And again, the land court and then the appeals court after it in Harrison validated the fact that your Section 5B provides no more relief than the statute. So I think that a board is entitled to a substantial amount of deference in the interpretation of their own statutes. And if it was fairly ambiguous and there was no case law in and around this very specific provision, I would be comfortable with kind of changing interpretations over time that are reasonable. But here, this very same language has been adjudicated not just by a trial court, the land court, but by the appeals court, which sets binding precedent. So to me, as a lawyer, whether we might think a different outcome should be warranted vis-a-vis what we're trying to do in Chatham with, improvements to commercial structures, I'm feeling quite bound by the opinion of the Harrison judge, as well as the other case law, including Rockwood, on this matter. I know it's kind of a roundabout answer to your question, but I hope it was helpful, Dave.
Well, that's okay. It's, and this is probably my ignorance, but another thing that I noticed when we're talking, and I'm not going to second guess judges, but I did notice that, when you've mentioned in the part of the Harwich bylaw and our section 5B very, very closely track the wording in 40A section 6. But in that line, or in those lines of 40A section 6, I don't see that there is a slight difference in that. So Chatham zoning bylaw says, provided, zoning board of, in our section says, provided the zoning board of appeals finds that such extension, alteration, or change, I'm ahead of myself. So in ours says, if I go up a line, it says that other pre-existing non-conforming structural uses may be extended, altered, or changed in use by special permit. That by special permit is not in that place in those lines in 40A section 6 that I can see.
But doesn't that relate to residential?
No, well, no, not because we're now so I see, and perhaps I'm wrong, tell me if I'm wrong, but under 5B, there are the first two paragraphs, and it starts with says enlargement, extension, or change. And the first says, as provided, and talks about single or two-family dwellings.
Right.
Then this next paragraph says other pre-existing non-conforming structures or uses may be. And it does insert, I believe it seems to appear to insert by special permit there. So I'm gonna ask you guys to weigh in on this as well, but
Okay.
I'm with
All
Jay right now. And so I'm learning more than I feel like I should probably. But
Is your question that whether or not that only applies to residential, or does it also apply to commercial?
well, yeah, so my question is, does the way that's presented in the Chatham bylaw does that make the distinction between the one and two family dwellings and when we say other pre-existing non-conforming structures?
Yeah, I had the same question, counsel, so help us out with that.
Sure. If I was guessing, what I would say is that the folks that put this together in your bylaw kind of separated into paragraphs the sentences that are in the first paragraph of chapter 48, section 6. The operative language that we're talking about with chapter 48, section 6 is like midway through that first paragraph where after they talk about some other things, they say pre-existing non-conforming structures or uses may be extended or altered, provided that no such extension or alteration shall be permitted unless there is a finding by the special permit granting authority or by the special permit granting authority designated by ordinance of the bylaw, that such change, extension, or alteration shall not be substantially more detrimental than the existing non-conforming use in the neighborhood. So that's essentially very close to the language that you have, except it says other. And I think the reason it says other in yours is because it's separating it from the previous paragraph, which relates to single and two-family structures. In looking at the appeals court decision, which upheld the land court decision in the Harrison case, the very last line states, lastly, the judge correctly rejected the argument from the St. Pierre's that the Chatham zoning bylaw is more permissive than the corresponding section of the enabling statute. And I think that was because both the land court and the appeals court concluded that the language that I just read from 48 section 6 is substantially similar to the language that you have in that second paragraph of chapter 5B.
Right, right.
Do you have any more actual questions?
I guess that's my main
Well, you
point.
get to
But,
talk during deliberations as well.
Yeah, I could talk to him.
Yeah.
And so, yeah, I think that's one of the main,
Yeah, that word other is tricky. I was stuck on the same thing.
yeah,
Yeah.
okay.
Ed, questions? Just questions at this juncture.
I'm gonna wait until we have discussions.
All right. And David Nixon, questions?
Yes, I'd like to introduce into the conversation our building commissar, because it's your decision that they're appealing. And I do believe that we need to hear from you. Has anything transpired since we met in December to make you in any way change your mind as to the absolute need for a variance?
Jay Briggs.
Jay Briggs, Building Commissioner, Town of Chatham. No, I haven't changed my mind on anything, and I think the thing to stress on the second part of 5B for other structures is where Jay's hitting it home, intensification. Yeah, you can expand a non-conforming structure, a commercial structure, as long as the expansion complies with the rest of the bylaw, but the intensification is what would trigger the variance. So in this particular application, the increase in height, although they've got it down to 18 inches above the ridge, and the number of rooms based on the amount of upland on the lot, I still think that they each require a variance.
Thank you.
Okay. Paul, questions?
I'd like to, just to get off Jay for a bit here, move to the February 6th letter to the board that was sent by Sarah. And that, I was a little confused by some of the language there in the second paragraph, which said that during the investigation into lowering the height of the elevator, it was discovered that due to the historic age of the structure, the rooms on the second and third floors cannot be made ADA accessible because the hallways on those floors do not provide sufficient width. In consequence, the project team went back to the original elevator design serving all 3 floors and revised the design to lower the overall elevator shaft as much as possible. I'm confused by the idea that lowering, how does that make it ADA accessible on the second and third floors?
Well, Paul, if I could respond?
Yes, go ahead, Attorney Riley.
All right, so it's the first and second floors that can't be modified. So the purpose of the elevator is to get ADA folks up to the third floor where all the rooms will be ADA accessible. So and the idea of lowering the ridge of the elevator shaft, or elevator building, was to make it as palatable as possible. I also think that I don't think a variance is needed for that. I think it's a simple special permit because the existing building's already a little over 30 feet. But anyway,
Well, what
that's,
what is it that's making a need for, I mean, this structure pre-exists ADA. And what is it that is making it necessary for it to be ADA accessible at all?
So it would be the amount of money spent on the renovations. There's a trigger, a dollar amount trigger, or
Okay.
a percentage of the value of the building.
So it's the project itself that's requiring it to be ADA accessible.
Correct.
If you did not do the project, if you didn't do the additional rooms, and/or add the wine room and elevator, there's no need to make it ADA accessible.
Correct.
Is that correct?
There's no trigger.
And as you say, the inn has existed as the most historic inn on the Cape. You're sort of trapped there by the fact that you have a successful inn that's been going for a number of years without ADA accessibility. And now, because of this project, you want to create something that is. Is that correct?
yeah, could I respond to that, Paul?
Sure.
What it does, I'm particularly sensitive because I'm a adaptive ski instructor in Waterville Valley, have been for 30 years, helping people with handicaps go skiing. And what's happening here is that a certain part of the population is barred from going to this inn and enjoying all the wonderful things that this wonderful historic inn has. And so the reason they passed the ADA is because people with handicaps were being abused and shut out of places. And that's the whole purpose of the ADA Act. And so to have a successful business, one of the points they now advertise is accessibility. I was involved with the Wauquasit Inn on a zoning issue. They wanted to enlarge some of their cottages down there. And the reason they were enlarging them is to make them ADA accessible. I think, you know, because it's been successful in the past, doesn't mean it's going to be successful in the future. I think it's going to be important to them to be able to provide this. So that's why we think it's important.
Yeah,
I
if I could
understand
also-
that, and I think probably all of us on the board will agree that ADA accessibility is a desirable thing, and we would enforce it and encourage it.
Great.
You've pointed to the decision of Harrison and the fact that it was limited because it was talking about reconstruction and also because it was making findings under our zoning ordinance that didn't extend as far as the issues that you're trying to deal with here. Isn't it also correct that normally a court would not go to issues which it did not need to reach in order to make a decision on a more limited basis, if possible, such as what Harrison did?
Is that for us or for Jay?
I'm asking
Who
that,
wants that
Bill
one?
or
Anybody?
Eliza. You have to answer.
Yeah, I mean, I think,
can answer it.
as we've said, that Harrison is limited to the question of whether the local bylaw, whether 48 allows for reconstruction, which it doesn't. And then the court also looked at whether the local bylaw is more permissive as it relates to allowing reconstruction of a non-conforming structure, which your local bylaw is not on that issue. Your local bylaw is, though, we suggest, more permissive in terms of allowing existing non-conforming structures to be extended by special permit. And again, I come back to 5B3. If town council's interpretation is correct, then that language has no meaning. That language explicitly says that the board is to consider the extent of the proposed increase in the non-conforming nature of the structure or use. again, that's one of the things that the board considers by special permit. If you take the position that you cannot extend, enlarge a nonconformity, then that language has no meaning, and that can't be the correct interpretation.
Okay, thank you. I don't have any other questions.
Okay. Lee, questions?
Yes, just a quick clarification to follow up on the ADA rooms available. 6 new rooms, hopefully on the 3rd floor. Did I hear that 2 out of the 6 would be ADA? 2, okay.
Yes.
Not all of them. Okay, thank you.
Okay. Steve, questions?
Just to, I might have 2 questions. Just to kind of expand on Paul's question, the first and second floors are not currently ADA compliant, is that correct? Because the hallways are too narrow?
Yes, that's correct.
Okay. So if you go ahead with this addition and create rooms on the 3rd floor and an elevator shaft, how are the ADA folks going to get to the elevator if they can't go down the hallways?
We have an outside entrance for them.
So they're going to be made to go around the exterior of the building and up a ramp to the elevator?
Well, the parking lot's in the rear of the building, Paul, or pardon me.
Steve?
But yeah, I was close.
Yeah.
Anyway, yeah, so all the in guests come in the rear of the building. The dining guests walk in the front door,
Okay,
but the in guests come in the rear.
okay. And then the second question I had is, because maybe it would help with this intensification question, have you thought about creating some sort of temporary structure to simulate the height of the elevator shaft? In other words, and I know there was a sketch made up from how the building would appear from across the street. Well, that's a sketch, and you could just leave the elevator off and say, well, you can't see it. Is there some way to make some kind of temporary, put up a flagpole with a flag on it to simulate the height and the location of the elevator shaft, so you can actually see if you can see it from across the street, and if it is actually an intensification?
Steve, are you suggesting that the plan that was drawn was deliberately modified so you can't see it?
It's from different angles. I don't know. It said it was from across the street, but I don't know that.
They showed it from the east so you could clearly see the elevator shaft. And then the guy drew it from the other side and using the same height of the ridge, just the angle of the view, you can't see it.
Okay.
But you can see it from the sides.
Mhm.
We're not trying to hide it that way. We're just trying to reduce it
Okay.
because there was so much adverse comment on it. And if you look, while we're looking at that picture, if you look at the bottom of the elevator shaft, there's a door. You see that?
Yes.
Okay, so that's how people would get there into the elevator shaft without having to go up any stairs.
Okay. All right. Thank you.
Okay, so I'm just going to intervene because this is part of Steve's question. Attorney Cox and Attorney Riley, you suggested that there's an entrance from the rear of the building. We put up the elevation, the rear elevation. Could you kindly point out where that entrance is?
You have to
Is it,
take the plan view,
I think,
because
yeah,
you have to take the plan view and look down on it. Because whoa. We have a,
Tell you that you're gonna get it on the ground.
see can you go back to the original building? What's this? What is 17? All right, so they don't show the decks, but there's a deck and a walkway that goes where the number 11 is. And then you see there's a roof section, there's a door, but there's a roof section to the right of the door, and that's an entry into the lobby.
Are you saying that there's a ramp there that we're just not seeing?
Yeah, it's not being shown. It's not a ramp. They're stairs.
Okay, well, how are stairs ADA compliant? I mean, maybe,
They're not ADA compliant.
okay, so how does somebody
That's
in a
the whole
wheelchair
point.
get up this, that would, we're just asking questions here.
Oh, I understand. Okay, so we have to go back to the back view we were looking at of the proposed. All right, just to the right of the stairs, with where the number 11 is. See that? You go to the new 19, because they're showing two different buildings there in one.
Maybe we could agree that you'd have to put in something back there. What you wanna,
No, there's a door. I just pointed out. Scroll that up a little bit. There you go. Whoa, hold it. Okay, the bottom of the elevator shaft has a door. See that? So here's the well, I can't. Right, so take your arrow, Sarah, and put it on the top window of the elevator shaft. All right, go down to the lower window. Go down to the lowest section. That's the door that people will be able to get in without having to go upstairs.
we can't really see, but are you saying there's no stairs there that you just roll right in?
Right,
Okay, it's hard to tell, but thank you for pointing that out.
okay.
Okay, very good. Virginia Fenwick, questions?
Well, I don't want to beat a dead horse here, but I too had questions about that paragraph on page 2 on the February 6th letter. So I think what Jay Briggs is saying is that the ADA access is only kicked off because of the cost of the project. So are we saying that a brand-new set of new rooms do not need to be ADA accessible? Like, that's not required?
Well, the cost would probably meet the trigger.
But if the cost weren't I mean, it just, you don't have to have ADA accessible rooms for a new building, regardless of cost. That's not a requirement?
You would, yeah. For new construction, yes.
Okay, so it's not just kicked off by the cost of the project. So why don't all 6 of the rooms have to be ADA accessible?
Because they have criteria, certain levels based on the number of rooms, how many they would need.
Okay,
Yeah.
so,
I mean, I don't know that they couldn't get accessible rooms on the first or second floor. They're saying they can't, but I don't know that. I haven't looked at any of the
well, that
plans.
was the other confusing thing I thought about that paragraph, is it doesn't say the first floor, it says the second and the third floor. So, I don't know,
Well, I think that was a typo on their part. I think Bill cleared that up.
yeah.
I think he said it was the
Yeah,
first and
that
second
was a
floor, and
typo.
that's why they'd have to put the
Okay.
accessible rooms on the third floor.
okay, that's
Yeah.
what I wanted to clarify. I'm sorry, Mrs. Cox, is that what you were going to say?
Yeah, I'm sorry about that. That is a typo in the letter. It's
Okay.
the width of the hallways
Yeah,
on the first,
on the first and
second
second.
floor are
Okay.
too narrow, correct?
Okay, so my initial question before I even got to that paragraph when I was reading was, do the new 6 rooms require ADA access? And I'm hearing the answer is no. Is that correct?
Two of them do.
No, they would.
A minimum of, yeah.
All
Has
6
to
of
do with the
them?
number
No.
of rooms.
Not all 6 of them.
Okay.
Would they require ADA access? Yes, a certain percentage. Is it 2? I don't know. I
Okay.
haven't checked that out, but I would
Well, I
assume that
think it
it's
was-
probably 2.
I think that it was confirmed that it was 2. Okay. Thank you.
Right, Paul, we're gonna close the hearing?
I'll move to close the hearing and move into deliberations.
Dave Veach seconds and votes yes.
Yes,
All votes yes.
Ginny votes yes.
As do I. Okay, deliberations. Well, Dave Veach will just let you roll. Just get it over with.
Well, first, I want to point out that I'm not voting today on this matter.
That's right.
Because
Oh, that- lucky
Steve
you. Lucky
participated
you. Yeah,
in
so,
the initial one, and I did watch the meeting, but in deference to all of our skilled associate members, I'm happy to not intervene and let Steve take the vote. Well, that said, I think based on everything that I've heard with respect to Jay's decision, and Jay Tellerman, as our town attorney, I think is presenting a conservative interpretation of all of this case law, and in order to help protect the town. I'm really on the fence because, as I said when I was doing the questioning, I just, and I'm happy to have learned in this process that there's the opportunity, if our bylaw currently does not allow these, give a little more latitude to commercial buildings and uses, then I would certainly like to have us have a conversation with Jay about how we might be able to achieve that if we don't currently have it. And I also appreciate that Attorney Cox and Nutter and Attorney Toronto Flores have, I think, shown maybe a little daylight in the opportunity. Perhaps I would be very interested in what a judge would have to say about this matter that we're talking about, because either way, I would lean towards with upholding Jay's determination. I think he's made it in good faith and with all the best information available. But I would definitely be wanting to take a very good look at the criteria for a variance, so.
Yep, and so that vote is going to be whether to deny the appeal of the building commissioners. So what do you say about that?
Were I voting, no, I would.
You would
vote
deny
to,
the appeal?
No, I would deny, yes, I would deny the appeal.
Right. I just want to get
Sure,
everybody used to the language that we're going to ask you to vote on in a little bit, because it's tricky. But Ed Acton, what say you?
I am not voting as well, but I've read the Harrison case. I feel both of these are very similar. So I would be inclined to go along with J&J, but we do have two attorneys on our board that I'd like to hear from as well.
Okay, we'll try that. Dave Nixon?
Well, I'm convinced that this is, I shouldn't use the word substantial because that comes in other discussions. But anyway, the intensification here is huge because you have a scenario right now where it's non-conforming by, and for the folks who don't know, you need to have so many square feet per room and square feet of land mass. And they're about 20,000 square feet short as we speak. And so if you added in another 6 rooms, that's times 3,000 per room, so that's another 18,000. So this is a huge intensification. And as such, I don't see that there's any leeway anywhere as far as feeling that Jay's decision was incorrect. So I will vote to deny the request to change his name.
Yep. Okay, Paul, what say you?
Well, I have looked at both Rockwood and at Harrison and the opinions there, as well as Titcomb. And it seems to me that the court's fairly clear that our ordinance would not be such that would be considered to be liberal enough to increase the availability of the request that's being made here. It seems to me there's definitely a need for a variance under these circumstances. Not that we couldn't at some point in the future change that law, that ordinance, but we haven't done that at this point. So I agree that we should sustain the decision by Jay Briggs, the commissioner.
Okay, thank you. Lee, what would you do if you were voting?
Yes, I am not voting today. And I have to admit, I'm on the fence. I can see both sides. But with my limited experience, I definitely will defer to Jay and Jay. And if I were voting, I would go along with my colleagues.
Okay, Steve, you are voting.
Well, I think it is an increase in the nonconformity. It was the good example given by the town attorney, that if you are increasing or decreasing the setback on a building that's already too close to the setback, then you're increasing that or intensifying that nonconformity. And I think by adding that elevator shaft to an already nonconforming building height, is intensifying that, and as well as the requirement for the additional square footage for the additional room. So I would certainly vote in favor of Jay's decision.
Yep, and Virginia Fenwick.
Well, I'll note that we haven't heard from the second attorney yet, but I have spent a lot of time on this as well. I'm not an attorney, and I want to just underscore something Mr. Nixon said. We are talking about 82,000 square feet that would be required, and you're at 37. It's a 55% shortage of what you need. I do think that that's substantial. I am not an attorney, as I mentioned, and I don't think I have heard enough to go against what our town council and building commissioner are stating. So I too would deny the request for appeal.
No, there's no drum roll for anything I'm going to say. I was stuck on that word "other" as well, and if I were Nutter and Attorney Riley, I would have made the same argument. And I also would I hope we don't find out what a judge says, but I fear that we may. But we have a double layer here, and I'm just a lowly town volunteer, and I'm not about, I would possibly go against our building commissioner, I think I may have before, but I'm not going against counsel. I just think that's just not appropriate. I'm not here as an attorney, but I see both sides, and I am going to err towards the side of saying that you need a variance, and, and I'll be very frank, if I was going to vote on this for a special permit, my feeling might not be much different than it would be on a variance, because I think the intensification is daunting. So that's sneak preview. If you did come back for a special permit, I think it's concerning. So that being said, do you want us to take a vote? Yes. Yes, okay, very good. So we're going to vote, Paul, if you want to move to deny the appeal. Approve the appeal.
I'll move to approve the appeal as made from the determination by the building commissioner.
No, but we don't, yeah. Sarah, help
We
us.
move to approve it, but if we don't agree to approve it, we say no.
Okay, so a vote no sides with Jay.
Yes,
vote-
all motions have to be made in the affirmative.
Okay.
So a vote to approve the application is going with Attorney Nutter and Attorney Riley. A vote to deny is agreeing with the building commissioner's determination.
So if you want to agree with the building commissioner, vote no. Paul?
Paul votes no.
Did you moved it? Yeah.
I did move it.
Did we second?
He's not voting.
I'm not voting. so-
Okay, so you can't even second it. Okay,
I'd be happy to second.
And vote.
I will vote no.
okay. Paul?
Paul votes no.
Steve?
Steve votes no.
Ginny?
Ginny votes no.
And I do as well, so that's unanimous no. Good try. So next, we would vote on the variance. Would you like us to do that?
I think we should do the,
Oh, we're going to take a vote on the elevator?
I believe we have to, don't we?
So the variance is for the elevator shaft as well as the upland requirement for the 6 additional rooms.
So we rolled them both into one. We don't need a separate vote on the elevator shaft.
No, because they're asking for those two variances as
So
one
even if we
package.
thought the elevator shaft didn't need a variance because of technical issues, we still need to vote whether or not the upland requirement requires a variance. I mean, we have to vote whether we should give a variance for that. Okay, so,
All right,
Do you want them to be able to provide? Sorry, do you want them to be able to provide any other additional information related to the variance applications?
who's that question?
If they have any.
yeah,
Oh,
yeah,
I mean, if
Yeah.
if
I
they
think-
have any,
no,
sure.
we
So,
heard the
Madam
variance
Chair?
argument last time.
Yeah,
I
Madam
believe we
Chair?
did. Yeah, so, and it's already an hour and a half almost into this application.
Madam Chair,
Yes, Mr. Riley.
we do not wish the opportunity to make a further presentation.
You do not, right?
We do not.
Okay, very good, thank you. And so now we know your argument on the variance, you have it in writing, and you provided that last time through able counsel. So now we are gonna have questions on the variance, I guess, that's what we, no questions. We're gonna have a vote on the variance. All right, a motion to vote on the variance.
all right, I'll move to approve the application for a variance with respect to, number 130,
We're gonna vote with,
24-130.
And then we discuss it?
no, so we don't even discuss it.
Oh, you can deliberate if you'd like.
Yeah, well,
I think we should.
okay, I think we should deliberate on the variance as well. I think you deserve that, and the public deserves it. So we're gonna deliberate on the variance, and again, I'm gonna start with David Veach, we might as well keep on, third time's a charm. And, so you know that the three criteria are for a variance, do you think they meet it?
I'm probably not, I might be alone in this, I'm not sure, but under this, let me put it this way. Boy, this is why we get the big bucks, I guess, I don't know. You know, I mean, I would like to say that, given that I've watched any number of inns disappear in the town of Chatham over the last 20 years or so, be converted into residential properties, various things. I mean, and I'm not sure that we have a dearth of inns at this point. I don't really know. I mean, I don't know how much of that is economic and not, but we don't have many left. And so, and I don't think that, I don't agree with the position that was taken by the Old Village Association. When I look physically, when I look at the proposal here, I just don't think that it's going, if were it to take place, I don't think it's going to look out of place or look different, really significantly different, substantially different than what's there now. You know, adding some dormers, the elevator shaft. You're not really going to see that much from Main Street. Now, the Old Village Association is correct. You could go around and you can go down Chase Street and somebody and see it. But, you know, you're looking at the back of the inn anyway. I don't think that's going to be an impactful, truly impactful of the views. I happen to notice, which I hadn't previously, it's not of the same dimension or stature, but just a little bit closer to town on the opposite side of the street, and is an old house that was moved from Cross Street to its present location, that has a tower on the front of it that's probably taller than what's being proposed here for the elevator shaft. So I don't think physically it's going to look out of place. And I be inclined to be liberal in terms of, I understand the concerns about, the standard of the upland, and they're asking for a large increase for that. I also would note, and just want to note too, that I forgot and didn't ask any questions, but they haven't been to the planning board yet. So there hasn't been any discussion about parking yet, which may.
Let's just stick to the variance.
All right, we'll stick, okay. So anyway, I would, and I think there's a gain by having an elevator in the building.
Okay,
And so for those reasons, I would interpret that, that it is a hardship were we not to grant the variance.
Okay.
And it does meet the other criteria.
all right, thank you. Ed, what would you do with those three criteria?
Well, I don't, I agree with Dave that having an elevator could be helpful. And I agree with the historic business district that the dormers aren't necessarily going to be detrimental to the property, but I don't feel they meet the criteria for a variance, strictly speaking.
Okay, David Nixon, do you?
Well, let's talk about the criteria, because, number one, topography. This lot is just like several that go around, we'll call it a marsh, and it's street level, you're like there, and then you drop down, you go back. There's nothing unique to me about this lot, which you need to have. Secondly, and the big one, is hardship. Well, there's no hardship here at all. This is a for-profit organization that purchased this with the idea of running the inn and adding it to their portfolio, and they're looking for an opportunity to make some more money out of this. Well, that's great, but that's not a hardship, not at all. And if we look at my little chart that says needs and wants, well, they don't need this unless your criteria is, well, they need to make X amount more money, whatever it might be. This is just a want. That's all it is. And a want, you don't qualify for any kind of a hardship. You bought it, that's the way it is. You can't have a self-generated hardship, which is what the argument could be. It doesn't wash at all as far as the criteria goes for a variance.
Okay, Paul?
Well, I think as has been mentioned by Dave Veach and others, it's definitely a situation where if we were looking at a special permit, we would be in an area that we could perhaps work with and grant. The problem is that with the hardship, with the variance issues, we have a series of criteria that we have to follow. And when we don't, we get slapped down. But it pretty literally is right in front of us, and that is there a hardship, financial or otherwise, that's imposed on the petitioner? I think clearly the petitioner would be having a more successful operation if they had the additional rooms available to them, but to a large extent, I see that as a self-imposed hardship. The inn, as we pointed out, has been in existence for an extended period of time, operating successfully, perhaps not with the debt structure that it has now, I don't know. But the hardship issue is a real one. When we look at the topography, I agree with Dave Nixon in indicating that the slope off in the back side there is common to a lot of the properties along Main Street there in that location. It's not unique to this particular building. And if we're looking at the structure itself as opposed to the topography for some reason, I again don't see that as a structure that really creates a problem unless there's an expansion that requires ADA compliance. So I think for a number of reasons, it does not meet our criteria for a variance.
Okay, Lee?
Well, to start, I want to say that I think it's a really nice design. I think it's very attractive. I think it's in keeping with the historical nature of the building. And I also want to add that I'm always, always in support of Chatham businesses. As Dave Veach said, I would hate to see another inn disappear, because I think it's charming. I think it fits a great need for people coming to visit Chatham. I think that the criteria for the variance, the first one relates to the topography and the structure. And I think that this structure is unique in that it is very old. It was built before we even had zoning laws in Chatham. And realistically, if it were to be built, something were to be built there today, they couldn't build what they have there today. In order to adapt it, that's just a really unique situation for that particular inn. The hardship part of it is a little bit trickier. Chatham has changed a lot. People come to Chatham and they expect a lot more than what they used to expect. I think it would probably be more successful if they could have this addition and the elevator. I think the elevator would be helpful. I think allowing ADA accessible rooms would be a huge plus, but I'm struggle with the fact that that's actually a hardship, that they can't do that. I think that if we were to grant the variance and give them the relief, I don't think it would be substantially more detrimental to the public good, and I don't think it would derogate from the purpose of the bylaw, but I still struggle with the hardship. So I'm glad I'm not voting today.
Steve, you are.
Well, I don't think it meets the criteria for a variance, and, the end goal of this whole project is to get 2 ADA rooms. It seems like a tremendous expense to go through to get 2 rooms, and I think there's a lot more cost-effective ways to convert 2 rooms on the first floor to ADA compliance. So I think all of this is self-inflicted. So I wouldn't support it.
And Virginia Fenwick.
Well, I don't have really a whole lot more to add. The hardship requires all 3 criteria, not one of the.
Variance required.
I'm sorry, the variance requires that you meet all 3. And I agree that the hardship doesn't meet. The property was purchased in March of 2024, and it was, presumably a lot of due diligence, and it was maybe an assumption that it could go through, but I don't see how we can, I don't feel comfortable that they've met the hardship.
Okay, we can vote now. Would you like us to vote? Yes, you would. Okay, so.
We didn't hear from you.
You didn't hear from me, and it doesn't meet the hardship criteria. I agree with everybody else. And I've read your explanation, counsel, about with all 3, and I don't think it meets the criteria with regard to any of them. And I struggle with your arguments, so I'll leave it at that. It's all in writing anyway, but I struggle with all 3 arguments. And I don't think an assumption should have been made that there'd be a special permit in this anyway. So, so now we're going to vote. Paul?
I'll move to grant the request for a variance made by the applicant.
I second that and vote no.
And Paul?
Paul votes no.
Steve?
Steve votes no.
Ginny votes no.
As do I, so that's unanimous. Again, thank you.
Thank you, Madam Chair.
Thank you.
We appreciate your time today.
And yes, and we appreciate your being remote, and we wish you well. And we thank town council.
We still have the special permit to deal
Oh, we
with.
still have the special permit to deal with. What do you want to do with that?
You voted on it.
Say again?
Oh, they applied for the special permit, right? So you have to deny that.
Yeah, we need to deny that. Or would you like to withdraw it and make our lives easy? No?
No.
Oh, well.
All right, I'll move to grant their request for a special permit.
And second?
Second that, and vote
No?
no.
Well,
All votes no?
Steve?
I don't know.
Ginny votes no.
As do I. Okay. You happy now?
Can we take a little?
We're always happy.
Yep. We're going to take
We
a break.
leave the zoning board always happy.
Yep. Likewise. We're going to take a break now, and we'll be back on the other side of the break. 5 minutes.
Thank you all.
We are back, and now we are going to go to the first application on the list, which is 24-153. David Dimitris and Giselle Lemonani, care of William H. Litchfield Esquire. Sarah?
Application number 24-153, David Madrasis and Giselle Lamentani, care of William G. Litchfield Esquire, 330 Orleans Road, North Chatham, Mass. 02650. Owners of property located at 107 Sequoia Road, also shown on the Town of Chatham's Assessor's Map 8D, Block 7, Lot R10. The applicant seeks to modify special permit number 23-073 granted on August 24th, 2023, which allowed for the construction of additions. The applicant now seeks to modify this special permit to allow for a new design. The existing dwelling is non-conforming, and it is located 20.5 feet from Geranium Drive. The proposed addition will be non-conforming, in that it will be located 4.6 feet from Geranium Drive, where a 25-foot setback is required. The existing building coverage is 1,019 square feet, 9.1%, and the proposed building coverage is 1,652 square feet, 14.8%, where 15% is the maximum allowed. The lot is non-conforming in that it contains 11,187 square feet, where 20,000 square feet is required in the R20 zoning district. A special permit is required under Mass General Law, Chapter 48, Section 6, and Section 5B of the protected bylaw.
Welcome, Attorney Litchfield. Nice to see you.
Litchfield here on behalf of David Magisteros and Giselle Lamentani, who are in the audience, along with some of their supportive neighbors. I think most of you were here in August of 2023 when I appeared before you with a proposal to make some changes to the existing house, which is a somewhat long neglected structure, which David and Giselle, who live diagonally across the street at 114 Sequoia, had recently purchased with the intention of renovating. I explained that we were there then and we're here again today to seek an encroachment into the street setback, not to Sequoia, the main street, but to Geranium Drive. And this portion of Geranium Drive is an unbuilt and will never be built portion of the original 1956 layout. You voted unanimously to grant the special permit, which allowed the house to be 6 feet from that paper street, Geranium Drive. David and Giselle started talking with builders about their plans, which included an upstairs bedroom. Several things changed. They were advised that having a full second story would require so much work, they'd have to tear the existing structure down. They didn't want to do that. They wanted to work with it. They also determined that keeping both bedrooms, and there are only two, and there will be only two on the first floor, made more sense. And for the person who's going to be living there, a longtime friend of their family. So they went back to the designer and modified the plans. There will still be a partial second floor, but only for storage. The new plan, though, shifts the house, while still small at 1,600 square feet footprint, 2 feet closer to that unconstructed portion of Geranium Drive. While you're out there, you saw the 35-foot width of Geranium Drive. You can see that we are not close to the northern abutter, who, like the other folks in the neighborhood, is supportive of this proposal. But because we are 2 feet closer to that paper street, we needed to come back to you for a modification. So I will go into the criteria. I suspect you'd like me to do so rather briefly. As to adequacy of site, the site remains adequate for the renovations and the modified additions. Except for the paper street setback, we meet the coverage in the primary street and side-lying requirements as the compatibility of size. On the last page of the handout, you have the comparable houses in the neighborhood, and we remain compatible. We have right now a very small house at 1,600 square feet. It will remain appropriate. The mass is minor, hardly noticeable, certainly a change from what's there, but consistent with the neighborhood. Living area is less than 1,300 square feet. As to the extent of increase in nonconformity, we are 2 feet closer to a secondary paper street, which is and will remain unbuilt. It was not taken by the town when the town took the other roads. There's no impact on the natural environment, but replacing the cesspool with a Title V will be an improvement for the environment and for the neighborhood, as will be creation of a house and a yard in keeping with the surroundings. And by the way, Giselle has a friend who's a master gardener who is coming out to work with her. on planting vegetation within that paper street. That's why they removed the invasives and other things that were in there. As to compatibility of use, it'd be year-round residential use, adequacy of water and sewer. The health agent has written, I think sewers will be down there maybe in my grandchildren's lifetimes, but they are coming. But there's no change in the number of bedrooms. So the other criteria are not at issue. The question, as you know, is whether the proposed new house with somewhat greater but consistent living area is substantially more detrimental to the neighborhood, given what is there now, which is detrimental. We don't have a particularly high hurdle to meet. The proposed change is obviously closer to the paper street than what's there now existing, but only 2 feet closer than what was previously approved. The northerly abutter approves, the person on the north side of Geranium Drive, as do a number of other neighbors who have written in support, and those neighbors to the right at the end of so-called Geranium Drive at 15 and 16 C Strand and 91 Sequansit are all supportive. The paper street, again, is exactly that. It's not going to change, and you should bear in mind that if you approve this modification, the addition, nominally 4 feet from the street, will be 39, almost 40 feet from the northerly abutter's setback. So the street provides a buffer, much more than it does as a means of transportation. So in light of the criteria and the plans given this location, I think you can find that the proposed change is not substantially more detrimental. Be happy to answer any questions.
Thank you so much. Is there anybody here on Microsoft Teams that wishes to speak in favor of this application? If so, please raise your hand. Yes, ma'am. Please just go up to the microphone and identify yourself. Did you happen to write a letter?
No.
Okay,
Oh, I did.
you did. So you're going to speak instead of your letter then, is that all right?
Yeah, sure.
Okay.
My name is Jane Wilson. I live at 6 Geranium Drive, across the street from 107 Sequansit Road. I'm here today to offer my full support and approval of the revised plans for this property. Currently, there's a wide area of open space on the north side of this property. Giselle and Dave has described this area as an abandoned paper road, which was found on a plan from long ago and never built. From my perspective and view, this open area allows plenty of clearance for the proposed addition to 107 Sequansit to fit appropriately on the lot and into our neighborhood. I strongly urge that the board approve this modification to the special permit as previously granted. Thank you for your time today and your dedication to keeping Chatham a special place.
Thank you, ma'am. Is there anybody else here or on Microsoft Teams that wishes to speak in favor? Seeing none, I will read the correspondences, but I will not.
Madam
Yes,
Chairman,
ma'am.
if it
Yes,
would
sir.
help the board, I would, on behalf of the applicant, waive the reading of the supportive letters because I know that the board members have already read them.
Oh, very nice. Thank you so much. And I will read the health letter, even though that doesn't not support. Our health agent, Judith Giorgio, tells us yesterday, 2/24/25, maybe the day before, I have reviewed the plan to renovate this property. The plan as proposed does not add septic flow to the existing property. The plan calls for existing cesspools to be abandoned and replaced with a Title V septic system. The plan as presented is acceptable. The septic plans and application must be made to the Health Division prior to the sign-off on the building permit. The property is deed restricted to 2 bedrooms, and a permit has been issued to replace the system. Okay, and I will waive we have the reading is waived for letters from Mr. Elliott, Rosenberg, and Breslin. So with that, is there anybody here on Microsoft Teams that wishes to speak against this application or has a specific question? Seeing none. Questions from the board? I'm just going to go, are there any? Seeing a lot of head shake, no, very good. Paul?
I'll move to close the hearing and move into deliberations.
Steve, did you have a pressing question?
Dave Veach seconds and votes yes.
Yes.
Paul votes yes.
Ginny votes yes.
As do I. Okay, now deliberation. Steve, you can slide it in there.
Okay. Well, I think it's a nice project, compared to what the house looks like now. The question I was going to ask was, who is responsible for maintaining the paper road?
No one. The applicants and the Breslins who live on the north own the fee, the underlying land, but it's subject to the right of anyone in the neighborhood to use it. Well, no one has used it in the 70 years it has been there. And until Giselle and David cleaned it out, you couldn't get into it anyway. So the maintenance will be done by the immediate abutters.
Okay. Any other? Okay. Ginny, deliberations?
Well, I think that it's, the project is an improvement to what's there, and it's an exciting project, and I don't have a problem with extending a little bit closer to a non-existent road.
Right. And Lee?
Yeah, I agree with Ginny. I think it's a nice project, and I have no problem with the new design.
And Paul?
I think it meets all our criteria, and I intend to approve it.
David Nixon?
In no way is it substantially more detrimental to the neighborhood, so I'd be in favor.
And Ed?
I agree with my fellow members.
And I agree with all the previous.
Okay, as do I. Paul?
I'll move to grant the application as submitted. I'm not sure that I see any need for conditions here, given the location.
They were not imposed in the 2023 decision, so we would ask they not be.
And I'll move to approve the application as submitted.
Dave Veach seconds and votes yes.
I vote yes.
All vote yes?
Ginny votes yes.
As do I. It's unanimous. Congratulations.
Thank you very much.
All right. Now. 112 Inlet Road is next. Robert and Mary Bainbridge, care of William Litchfield. Are we going to do that last, or? Huh? Oh, I'm sorry. What is next? This one? Okay, so we're going to do 25-001. My copy has the other one first, so I apologize. I might have picked up the wrong copy. 322 and 324 Bridge Street, care of James Norcross Esquire. Sarah, whenever you're ready.
Application number 25-001, Casa Investments, Inc., care of James M. Norcross Esquire, P.O. Box 707, Chatham, Mass. 02633. Owner of property located at 322 and 324 Bridge Street, also shown on the Town of Chatham's Assessor's Map 16B, Block 13, Lot 4A. The applicant seeks to enlarge, extend, or change 3 nonconforming structures in a nonconforming lot via the demolition of the existing dwelling, guest house, and shed, and the construction of a new dwelling, guest house, and garage. The existing dwelling at 322 Bridge Street is nonconforming in that it is located 15.6 feet from the road, 24.9 feet from the westerly abutter, and has a building height of 30.5 feet. The existing guest house at 324 Bridge Street is nonconforming in that it is located 15.1 feet from the westerly abutter and exceeds the floor area allowed for a guest house by 20 square feet, 50.8%. The existing shed is nonconforming in that it is located 6.9 feet from the westerly abutter. The proposed dwelling at 322 Bridge Street will be nonconforming in that it will be located 15.6 feet from the road where a 40-foot setback is required and 13.4 feet from the westerly abutter where a 25-foot setback is required. The proposed guest house at 324 Bridge Street will be nonconforming in that it will be located 16.4 feet from the westerly abutter where a 25-foot setback is required. The existing building coverage is 1,583 square feet, and the proposed building coverage is 2,364 square feet, or 2,850 square feet is the maximum allowed. The lot is nonconforming in that it contains 23,724 square feet, where 40,000 square feet is required in the R40 zoning district. A special permit is required under Mass General Law, Chapter 48, Section 6, and Section 5B of the protected bylaw.
Welcome, Attorney Norcross, and welcome
Thank you very much. For the record, Jamie Norcross.
Karen Kempton. Yes.
Jamie Norcross representing Steve and Barbara Benincasa. Steve Benincasa is here in the audience in the back today. Barbara is participating remotely. With me is Karen Kempton, the architect for the project. It's been, I know you've You've had applications for this property previously, although it's been a couple years, so going to go through a little bit of overview, and then Karen will review the plans and the changes that have been made since the last time it was here. Sarah, if you don't mind bringing up the site plan, I'll just go through the nonconformities, the existing and proposed, as it is a little bit somewhat confusing given their two structures. Great, thank you very much. So we have a non-conforming lot. It's 23,700 square feet and change in an R40 zoning district. We're also non-conforming as to frontage. 150 feet required, we have 100. In terms of the existing structures, so the existing front house, we'll call it, is here, outlined in purple. That's non-conforming as to the street setback. It's 15.6 feet. It's also non-conforming to the west lot line at 24.9 feet, where a 25-foot setback is required. The existing cottage, we'll call it, is this red building here, which is proposed to be demolished. That is non-conforming. To the building, it's 15.1 feet to the west lot line, and then the deck you see right here is actually only 3 feet off that corner lot line currently on the existing cottage. There are also a couple additional structures on the property. There's the shed that you see down here. That's about 6 feet off the lot line currently. That's proposed to be removed as part of this application. And there is also the existing AC condenser down in here, which is about 3 feet off the lot line. And that is proposed to be moved closer to the house and would meet the 25-foot setback in its new location. With that, I'd ask Karen to go through the design, and then I'll run through the criteria after that.
Hi, Karen Kempton, architect for Steve and Barbara Benincasa. Sarah, if you can pull up those photos that I have. The first one is of the existing front elevation. Okay, so since our last hearing in October of 2022, we have made significant reductions in building coverage and gross floor area on this property. As a reminder, the existing house, according to the Massachusetts Historical Commission, is a 1.5-story dwelling with no discernible architectural style built into the roadside escarpment on Bridge Street. The front door of the house is on the east side, so if you can go to the next photo. You can see the front door just around the corner on the driveway side. This enters the first floor, which is below grade on Bridge Street. So the existing second floor bedrooms are at grade on the front, and those are the two windows you see on the front elevation. Those are for the second floor bedrooms. Then the 3 windows you have above are for 2 bedrooms in the attic space. The guest house at the rear is a gambrel, if we go to, there you go, and is located 6 feet off the corner of the main house. It also blocks views on the westerly side of the house and is 15.1 feet off the property line. The AC units, as Jamie said, are 3 feet 8 inches off the property line. And the second floor deck, which you can see, if we go back to the gambrel, yep. You can see the second floor deck there. That is 3 feet from the property line and is 12 feet above grade. If we go to the next one, which are the aerial views, you can see that the length of the 2 structures are so close to each other that they appear almost as one structure. So that's, if you can see right in the middle, correct. That's 6 feet between the 2 structures. The lot is heavily buffered on the east and west sides by mature trees and a large hedge. So you can see the large trees there on the west side and on the east side. And for a sense of scale, you can see a portion of the adjacent house at 326 Bridge Street, which is the gambrel located on the right-hand side of the photo. The next one, I believe, is another aerial. Yep. So again, we're in the center of the photo, and you can see some of the adjacent properties the houses to the west of us and the one to the east of us. The next photo is of the existing basement of the guest house, which we can discuss later. And the next photo is 306 Bridge Street, which is the abutter to the west, fronting Bridge Street. It is a 1.5-story front wall with a dormer cut into a steeply pitched roof. The next one is 310 Bridge Street, the abutter to the west on the same lot as 306. Their garage faces the rear. If you can just see that the left-hand side roof line, that's their existing garage. And you can't see it in this photo, but there is a 6-foot stockade fence separating our property from their property. If we can go to the model and just freeze on the front elevation. There you go, just freeze it right there. We have kept the original gable-fronted salt box style of the house to be compatible with the neighborhood. We felt it would improve the streetscape of the house and the utility of the house by having a front door entry on Bridge Street with a welcoming front porch. The first floor is now at the Bridge Street elevation, and only the second floor windows are above. The front porch aligns with the existing front of the house, so that the actual salt box wall is 7 feet back from the existing house. The second floor is now under the eave line and has 3 symmetrical windows across the front. The width of the front elevation remains the same as the existing at 26 feet. We have dropped the ridge height 2 feet 4 inches from our previous proposal and have changed the pitch of the roof from a 15-12 to a 10-12. This also makes the ridge height conforming, under by 5 inches, and more importantly, lower than the existing non-conforming ridge by 4 inches. In this way, we think that the streetscape is not substantially detrimental, just the opposite. We think it is a more aesthetically pleasing and approachable house from Bridge Street. There is a proposed deck on the right side, which you can see behind the vegetation. This will be at the first floor elevation and at grade from Bridge Street. The deck, which is needed for a second means of egress, is in the same location as the existing patio that was on the lower level. Because it is a deck and a structure, it is non-conforming on this side. But we feel that the utility of the deck in replacing the existing patio, so there is not an increase in usage on this side of the house. The main house does conform on this side, as it is 25.4 feet back from the west property line. It's just the deck that is noted on the side plan that is at 13 feet. We also have and the existing house on that side is non-conforming at 24.9. So again, we are at 25.4. We have also proposed a pull-in parking area for guest parking to access the front door. There are other nearby properties on Bridge Street that have these parking pads right off of the road. We have removed the existing shed and have located the guest house further back and the east to open up the view corridor. So if we can go around, play the model a little bit, we go around to the left side. It's heavily buffered there by existing trees. We can pause it right there. We have removed the originally proposed detached garage to decrease the density and open up this area between the 2 structures. By eliminating the garage, we have moved the guest house 15 feet closer to the main house, opening up the backyard space even more. We have shrunk the previously proposed guest house by 1,051 square feet of gross floor area. A majority of this was done by removing the previously proposed walkout basement. So if we can just continue going around to see the guest house. We'll come around to the rear of it, and we can freeze it right there. We have also reduced the living space on the first and second floor by 211 square feet. This gets us up to the magic number of 1,290 square feet of gross floor area that was approved for the existing house by special permit in November of 2008. Additionally, we have removed the third bedroom, making this comply as a two-bedroom guest house. In addition to removing the proposed walkout, we will make the basement uninhabitable by creating a 6-foot 6-inch high ceiling, which will be not habitable by building code definition, and so as not to add to the gross floor area. Keep in mind that the existing guest house has 652 square feet of gross floor area in the basement and 366 square feet of finished living space. The finished basements photo I showed you before shows the 9-foot ceiling in the basement. When Steve and Barbara bought this property, they were not made aware that this basement space was built and not allowed by the special permit of 2008. Regardless, we are giving up the basement space to remain conforming to the intent of the special permit. We have designed the guest house as another gable-fronted 1.5-story structure with a covered porch, rather than the imposing 2-story gambrel that exists there now. We are 4 feet 9 inches below the allowed height, with the intent of making this structure subordinate in scale and mass to the main house. The second floor deck off the existing guest house is at elevation 30.8, which is 12 feet above grade. That's the existing guest house. The proposed deck at the first floor level is at elevation 20, so it is 10 feet lower than the existing deck. As I mentioned, we have moved the guest house 15 feet closer to the north, so that combined with the reduction of the house length, it moves closer 23 feet further out of the backyard. This still allows the neighbor's view over the property, although the west side neighbor does have a stockade fence, which you can see in the model as we go around, and there are garages on that side of the property. We can continue around to the other side. This is a heavily buffered area with significant trees and hedges on the east and west sides. We have relocated the AC units and generator that were 3 feet 8 inches off the property line to a new location, a now conforming location of 26.9 feet from the property line. So you can freeze it right there for a minute. So we believe that the scale, siting, and mass of this project are not detrimental to the neighborhood, as we have reduced the nonconformity of the front elevation and made it more aesthetically pleasing. Although we have increased the building coverage by 3%, we are below the allowed coverage of 2,850 by 486 square feet, so certainly not overdeveloped for this lot. We have made thoughtful additions in areas that are not detrimental to the neighborhood in creating a more aesthetically pleasing guest house with front porch to match the main house. Although this adds 274 square feet to the building coverage, we feel that they are important to the scale and historic feel of the neighborhood. So as you can see on the model, if we can continue around, I've added the adjacent abutters to give you a sense of scale from Bridge Street. And the aerial view. So you can see there's a much larger house at the rear of 326, I believe that is. And then you see the two houses on the west side of the property. And there's definite definition between the front house and the guest house. We hope that you agree that this is not substantially detrimental to the neighborhood. It is respectful of the original architecture and provides an attractive frontage to Bridge Street. And I'm here for any questions.
Thank you so much. You want to run through the criteria?
Yes, I will, Madam
Yep.
Chair. Number one, adequacy of the size of the site. We believe the size of the site is adequate for the proposal. It has a combined building coverage of 10.1%, which is an increase from existing, but it's still, as Karen mentioned, almost 500 square feet less than the maximum allowed for the property. Given the narrow shape of the lot, as you move further to the back, it's difficult to meet both setbacks, but we've tried to honor existing setbacks as much as possible for the cottage, and I think we've actually improved the situation, I would say, in terms of nonconformities, as we have a deck that's 3 feet off the lot line now, and as proposed, it'll be over 16 feet, the house, and the deck itself will be over 16 feet in only first floor as opposed to second floor. Lastly, again, I think placing the house in the middle of the lot really makes the most sense for a number of aspects, but in terms of the usage of the space and also creating more of a buffer between the two properties, as I'm sure you saw when you're out there, you can practically touch both buildings standing in the middle, which is a bit strange. So I think this is a much better use of the space on the lot. Number two, compatibility of the size of the proposed structure with neighboring properties. Oftentimes, it's quite unique for a property to have two residential structures, but in this particular neighborhood, going through, both driving around and reviewing the assessor's records, there's several nearby properties that contain both a house and guest house, and I think there's one that actually has 3 houses on it. On the gross floor area analysis that I passed out, you'll see the numbers for the 2 proposed structures for our application are consistent with numbers found for neighboring properties, in particular those lots that also contain 2 residential structures. Number 3, extent of proposed increase in nonconforming nature of the structure or use. Our increase is, main increase, I would say, is relative to the deck on the front building, the main house. That's going to be 13.4 feet off the lot line. As Karen mentioned, the house itself is actually meets the setback criteria. It's a shade over 25 feet, but the deck is an additional increase in nonconforming nature. We're actually, as I mentioned, removing a number of existing nonconformities, the shed, the air conditioner, and then the deck on the cottage. Suitability of the site. Site is suitable for the project. There'll be no negative impact on neighboring properties or the natural environment. Impact of scale, setting, and mass on neighborhood visual characters. Visual character, including views, vistas, and streetscapes. I would suggest there's no negative impact on neighborhood visual character. While the main structure at 322, so the front house, will be increasing in size, the height of the structure will be slightly decreased. Karen's design limits the size and scale of the home as viewed from Bridge Street. As she mentioned, the width is the same essentially as what's there now. She's using dormers to increase some additional living area on the second level. Also, by placing the rear cottage directly behind the main house, it also limits the visual impact as seen from the head-on view. You really can't see it behind there. And I think it's actually an improvement as seen from perhaps coming up on the side. As you see it now from coming up on the side, as Karen's photo demonstrated, it almost looks like it's one house. Mind you, a strange-looking house with those 2 designs, but it almost looks like it's connected. Now you're going to have a clear distance between those 2 homes, which I think from a massing standpoint is a real improvement and breaks up the structures on the property. Lastly, the guest house is, while it's moving back, I guess it is perhaps a little bit closer to the neighbor on the west. But from our calculations, it's still over about 70 feet away from that rear house. And as Karen mentioned, that house, the neighbor's house to the west, it's actually their garage that's closest to our property. 6, compatibility of proposed use with neighboring uses. Again, we're compatible with a residential use and residential neighborhood. Method of sewage disposal, we are installing a new Title V septic system as part of the project. No negative impact on traffic flow and safety. And I don't believe the others are really applicable. So again, Karen and the Benincasas work to address concerns that were raised. Obviously, you have a number of folks who are still written in, but I think we've made substantial progress with this design, with the changes that were made, and we certainly do not think it's substantially more detrimental to the neighborhood. So happy to answer any questions.
Thank you very much. Is there anybody here on Microsoft Teams that wishes to speak in favor of this application? If so, please raise your hand. I don't see anybody in favor. If there's any, I'm not going to ask right now that you get up if you want to speak in opposition, but I will say that we have a number of letters, and if there's anyone here that plans to speak that has also written a letter, could you raise your hand? No? Okay. I was trying to get out of reading some of the letters, but, oh well. All right, so now I will read.
Can we waive the reading of the letters? Is that
I wish you could. You can waive the one in favor if you want.
No, we want that one, please.
Yeah. Okay, so here we go. So this is from the Historical Commission, and they write to us on February 24th, 2025, that there's a long history with 322 Bridge Street. It appeared in front of them several times, and they find it to be historically significant, and the proposed changes will materially diminish the home's historical significance. Therefore, they imposed a demolition delay of 180 days. That expired a few days ago. No, February 22, 2022. That determination expired August 17th, 2023, the owner was unable to receive the Zoning Board of Appeals approval and ended up withdrawing their application. Then this delayed the project, so they reapplied, and then they were in front of them again in July 2023, continued to August 2023. In the August meeting, they reaffirmed 322 to be historically significant, and the proposed changes would materially diminish the home's historic significance, and therefore they imposed a 540-day delay. That delay expired February 15th, 2025. That determination expires August 15th, 2025. So the historic property is not in danger of collapse, as determined by the building inspector and commissioner, and the commission was hopeful that restoration could be accomplished to save the structure, and that was from Frank Messina. And then we have a note from Judith Giorgio, our health agent. She received the plans. She tells us on 2/24/25 that it will not increase sewage flow to the property. It was approved for 7 bedrooms. The new location will encroach on the existing septic and will require installation of new tanks. It's unclear if the leach field will need replacement depending on its distance from the proposed dwelling. Then we have a small balance due on taxes, just so you know.
Yes, that should,
I'm not going to read that, but just make it you aware. Then we have a note from Stephen Vicasa, and this is his property. No, Glenn Hoffler. He sent the email to Stephen. And Glenn Hoffler of 326 Bridge Street writes, in support of the proposed and long-delayed housing project on Bridge Street, and then he's the next-door neighbor, someone who's seen the full design of the plan. He supports the plan. He'd like to see the work in progress, including demolition of the older home on Bridge Street. The older home does not represent the type of antique home in any kind of preserved state that is worthwhile keeping. I am someone who is fully appreciative and committed to preserving the traditional aspects of Chatham and all its charm, and blending appropriately with the new construction done tastefully. Chatham is such a special place. Your plan appears to accomplish this and would be a significant improvement from the older home, which I view as an eyesore. Then we have a note from Noah Fleischman, 36 Harding Lane in Chatham. He says his family owns 309 Bridge, and writing to express their objection to the proposed zoning appeal that would essentially double the size of the existing house and cottage on 322 Bridge. We understand that what is now non-conforming, what is proposed requires even more, multiple exceptions to the existing zoning requirement, and it would not and should not be allowed. The undersized lot at 322 Bridge already has 2 structures. The guest house in the rear has already been enlarged by a special permit in 2008. We also understand a guest house can only have 2 bedrooms. When a special permit was granted for the expansion, the rear building was in fact a guest house. Now the design plan is to give the proposed second cottage a 3rd bedroom. The proposal should not be approved. It will have substantially detrimental effect on the neighborhood homes in terms of proximity, scale, and noise from short-term renters. While the proposed houses are not unattractive, shoehorning both structures and a garage into an exceptionally narrow lot further illustrates the need to enforce existing zoning in the neighborhood. Granting exceptions to too many non-conforming structures on too many properties is not in the best interest of Chatham or the town. Excuse me. After all, the zoning was put in place for a reason. This project should be rethought, reduced in scale, and resubmitted. We strongly urge the board to reject this permit. Next, Cornelia Atkins from 130 Champlain Lane in Chatham writes on February 25th, 2025, their property is located at 130 and 138 Champlain Road. It's been in their family since the 30s. As property owners, they made an effort to preserve the 18th century building and oppose the current plans for this application. Chatham suffers from overdevelopment and risk of losing its unique character around the old village. This latest proposal would demolish the historic house, overdevelop the site, and increase its nonconformity. If passed, this proposal is not appropriate for Bridge Street, and they ask us to deny it. Then we have a note from Roberta Williamson Seymour from February 21, 2025. My family has lived at 89 Water Street since 1937 and at another home on Water Street since 1911, and have been following with interest and frankly dismay the proposal to redevelop this property. The so-called guest house built in 2008 should never have been approved, but we hope that your board won't compound the error by allowing two large houses to be shoehorned onto this narrow lot, especially at the setbacks are not being followed. The effect of our old village neighborhood, the increase in nonconformity, and the mass of these two houses are all inappropriate for our historic neighborhood and for the town. We strongly urge you to deny the request. Andrew Robertson Black and Margaret Hewitt Black tell us on February 24th, 2025, that they live in North Chatham for more than 30 years. They came to Chatham to visit their grandmother, who lived on Bridge Street. We know this Bridge Street neighborhood well and love its quaintness and charm. Our concern with this application has to do with the size of the structures the owner proposes to build on this small lot. The lot is narrow and 50% undersized for the proposed new buildings. Much of what is there is now is non-conforming, and the size of the new structures will make it even more non-conforming to what is minimally required and would have a negative impact on the neighborhood visual character. It's disheartening to see throughout our town an increase in lot coverage by new dwellings, resulting in less green space and open land. This property abuts conservation, and lot coverage needs to be a consideration given the proximity of new structures and the compatibility of surrounding conservation uses. We hope the owner will work to reduce the footprint and an increase in nonconformity on any lot is not good for long-term development in Chatham. We are sure that 322 and 324 could be a great addition to this wonderful, long-established neighborhood. It's our hope that present owners will strive to work with their neighbors and the town to find a right balance of scale and conformity, and to be mindful of conservation land on the southern border. 32 Sunset Lane, Tracy Thompson Sundstrom tells us that she opposes the plan. She says so on February 16th, 2025. She understands that this application is before ZBA today. The proposed plan will overdevelop the property, negatively impact both adjacent property values, and undermine the quality of the neighborhood residents. Bridge Street has managed to keep its charm, and numerous houses being tastefully redone without becoming McMansions. The same cannot be said for many other parts of Chatham. These plans will tear down a registered historic house to build two larger homes for summer rentals that are not lived in by the owner. How is this even permissible in the old established residential area? If passed, it will not be an improvement, but the continuation of a destruction of Chatham's charm. We have a note from Bard Schlesinger from, February 24th, 2025. They own a nearby property on Bridge Street and are writing to express their objection to the proposal, essentially doubling the size of existing houses and cottages on 322 Bridge. We understand that what's there now is non-conforming in many ways, and what's proposed is classic overdevelopment and should not be allowed. This undersized lot already has two houses, one in the rear, already enlarged by special permit in 2008. We also understood guest houses can only have 2 bedrooms. When you granted permission in 2008, the rear building was a guest house, and now the proposal is to give a 3rd bedroom. How can that be done? It's already more than 50% the size of the main house, which shouldn't be allowed, and now they're seeking to increase it further. This proposal should not be approved. It will have substantially detrimental effect on traffic congestion, noise from renters. The second driveway should be absolutely not allowed, as cars would have to back down on busy Bridge Street, while proposed houses themselves are not attractive. Shoehorning them into a small lot has a negative impact. The scale, mass, and siting of what's sought is inappropriate. The visual impact is incompatible, and the project should be rethought, reduced, resubmitted. We strongly urge the board to deny the request. Then we have a note from Muffy Gibson from February 21, 2025. She tells us that she's opposed to the special permit. See where she lives, on 306 and 310 Bridge Street. Muffy and William Gibson write, the provisions of the section of the bylaw are intended to achieve the following objectives in conjunction with proposed changes in the non-conforming buildings and uses to promote, maintain properties and natural resources, to avoid creation of adverse impacts, and to reduce the size of existing impacts on neighborhood properties. And then she writes out basically the section 5, part B, 44 of the bylaw, and she lists all of the criteria that I'm not going to read because we've already gone through those. The special permit application under review would allow the existing non-conforming conditions to be increased on the following counts. This would adversely affect us in our enjoyment of our yard. It would not reduce or minimize impacts on neighborhood properties, just the opposite. The west-facing deck proposed for 322 Bridge Street is within 25 feet of the rear of the required setback, and so she objects to that. The change moves the outdoor living space for that residence 12.9 feet from within the westerly property line. Previously, the residence was 24.9, a worsening of that non-conforming condition. The residence on 324 Bridge is being relocated farther back on the property within an area that is presently clear of any structures. This alone is a significant step in worsening the existing non-conforming condition. The proposed structure is 16.5 feet from the west property line where 25 is required. As per architectural plans within the application, the square footage of the buildings has increased over 2,200 square feet. Again, this does not reduce or minimize existing impacts, just the opposite. As per the assessor's report, approximately 3522 square feet is proposed, and also 1271 for 324 Bridge Street. It's our understanding that property has and will be used for short-term rental property. The potential for this use is not compatible with our use. We are owner-occupied, and full-time residents will be negatively impacted by the revolving short-term rentals which come with noise and nuisance. If there was a way to ensure having a long-term neighbor, either as a tenant or owner-occupied, it would be a different story. Clarissa Rowe from 102 Water Street writes on February 17th, 2025, that she's reviewed the site plan, the architectural plans and details for the proposed changes for this application. And she says she's a registered landscape architect and owner in the old village. She has an eye for this type of overdevelopment. The owner has never lived here, may have no intention of living on the property, and is stuffing 3 structures onto the property in order to maximize his profit. The architecture plans show 3 buildings with living units in them, and the height of the buildings is excessive. The front building is not compatible with the neighborhood of small buildings facing Bridge Street. This will have a visual change to a unique part of town. Also, by including 2 parking spaces, the development, will affect the traffic along Bridge Street. Bridge Street is a narrow road. Pulling out a car in this traffic will be a safety hazard, and she asks us to reject it. See how many I have left. Just to let you know, 1, 2, 3, 4 left. I can do it.
You can?
I can do it. Yep. I'm a marathon runner. I can read. All right. Tuesday, February 18th, we learned from Lucy Parkhorn from 57 Silverleaf Ave in Chatham, and she also lives in Pennsylvania, that she's writing to oppose the plans. The family has owned in Chatham for 70 years. They take great pride in their neighborhood. They have been carefully, she says the properties have been carefully restored over the years and are in keeping with the guidelines of the historic district. The plans currently up for approval represent everything that diminishes the tasteful character of the historic area. And thank you for giving consideration to not accept these plans. Large impervious coverage will cause runoff issues affecting adjacent neighbors. Chatham is a jewel, and we'd like to keep it that way. Virginia Nickerson, 30 Bittersweet Lane of North Chatham, tells us on February 11th, though her letter primarily concerns 322 and 324 bridge, I hope that the members of the ZBA will take my thoughts into consideration for all applications. I believe the protective zoning bylaw was written for a good reason. Setbacks protect neighbors, firefighters, and much-needed vegetation, which is a habitat for our birds and animals. With every house that receives an approval from the ZBA to build up and out, we are losing our town to overdevelopment. Our houses are becoming excessive in size, overgrown houses are destroying our villages, our quaint sense of Chatham is being lost. I hope that members of the ZBA will not approve this oversized use of property and vote to send it back to the drawing board to reduce the overall scale and size. It already appears to be a rather large home and guest cottage. Thank you for your consideration. Sarah and Henry Bedford tell us on February 14th, 2025, that they also own property on Bridge Street, 396. They oppose this application. It's a 1770s house, probably the oldest on the street. It needs work. There are plenty of examples of sensitive restoration in the neighborhood that should be rehabbed rather than torn down. Obviously, the Historic Commission agrees. The proposed houses constitute a large increase in square footage. They're enormous. The plans have 7 bedrooms, unfinished space that can easily be adapted for more, as well as parking for 6 cars. Who can doubt this is designed to be another short-term rental? We should discourage that. The scale is way out of line with Bridge Street houses. Its inappropriate mass will overhang adjacent properties, especially the one on the west, interfering with light and enjoyment of much greater degree than the current structure does. With a house of this size, plus associated decks, porches, paving, where will runoff go? Please put a stop to this. We encourage the developer to come back with plans that are much more appropriate for the neighborhood, and that includes restoring the house. Martha Stone from 307 Bridge Street writes on February 14th that she opposes the Casa Investments Incorporated plan to build 2 large buildings on this lot. The proposed structures would adversely impact the Chatham neighborhood, dwarfing the 3 small cottages across the street. Please consider approving construction of dwellings that would be more compatible with the neighborhood. That concludes the written letters. Should we do now? You want to rebut now?
I'll wait to the end.
We'll wait a moment, yeah.
Thank you, though, for the.
Yes, audience, is there anybody that wishes to speak against this application? Yes, ma'am. You didn't write a letter, right? No, I didn't. Okay, when you get up there, just state your name. Thank you. And then we'll go to Attorney Litchfield next.
At least you don't have to read this one. Good afternoon, ladies and gentlemen. I am Ann Timpson, a Chatham resident, and my family have owned property in this town for 72 years. We accept that progress often means change, but tearing down 2 houses on one small non-conforming lot, one house being an historic Burst family residence originally built in 1770, and the other a rather new 2009 construction, seems both impractical and a dramatic visual alteration to one of our oldest streets and neighborhoods. These are some of my concerns. Based on the bylaw regulations for guest houses, which require them to be no greater in size than 50% of the main house, demolishing building number 1 and constructing a larger prototype will allow a larger guest house. It would also allow future additions to the new guest house without permission from this board, since it's slightly under 50% at the moment. The ordinance for historically non-conforming lots allows a purchaser to take advantage of existing out-of-code setbacks. Both front and side setbacks can be maintained at original locations rather than at present code restrictions. In the case of the main proposed house, the westerly setbacks have been dramatically decreased, not maintained at the out-of-code 24.9 feet from the westerly abutter, where 25 feet is allowed. The plan clearly shows 13.4 feet from the western abutter's property line. There is no legal rationale for permitting such a further transgression from existing building codes. Noise is one of the most important items listed in your criteria. Although decks are common on the back of summer homes, the size and location of the 18-foot by 12-foot level deck, only a few feet away from the westerly property line, gives the westerly abutter no privacy and no relief from outdoor deck parties and constant outdoor conversations or outdoor speakers for music. The square footage of this deck is approximately 206 square feet, which allows for a large event. Prevailing wind off the nearby water carries sound to all the neighborhood houses. And as the owner has already stated to neighbors, he intends this property to be primarily used for summer rentals. Historically, summer renters are not as quiet as their winter counterparts. We request that you consider only a small deck on back of house, not on the westerly exterior. A smaller sized deck confines the number of occupants and thus the noise and usage. The same issue arises at the rear of the guest house with a second-story deck with 280 square feet, including elevated stairs. We request these exterior living spaces designed for entertainment be lessened in size or eliminated. Bridge Street property owners have graciously allowed permitted beach parking along their street all summer long. They have become used to people ruining their lawns and blocking their driveways. 2 large new homes on an undersized lot cannot accommodate parking on site for up to 7 bedrooms of occupants. Based on 2 residents per bedroom, that could result in as many as 14 cars, not including guests or visitors. The driveway, as the only access to the guest house at rear of property, by law, must not be blocked by any vehicles, landscaper, or commercial autos or trucks. Fire, police, and rescue must have full access at all times. This plan does not include exterior parking for more than possibly 4 cars. 5, although the owner has
Just so you know, you have 30 more seconds.
Thank you. Although the owner has not exceeded the allowed buildable upland on 322 Bridge Street, he has left almost no green space and maximized his proposed structures, removing any landscape in view for his abutters. The small non-conforming lot is maxed out with 2 new buildings and no exterior space to create a natural buffer for view or sound control. The lot size is long and narrow, and these new constructions remind one of an endless oversized motel, not a private
Last sentence,
residence.
if you would.
Okay, last but not least, it is a stormwater runoff issue with flow going right into conservation land as well as abutters' properties.
I'm going to have to cut you loose, okay? Thank you very much. All right, next.
Thank you, Madam Chairman. Bill Litchfield here on behalf of the Gibson family. I will try to be brief because it's been a long afternoon. But this is at least the 6th time that plans from Casa Investments for this property have been on your agenda. And the lack of progress in making substantive and responsive changes is, I think, unfortunate. The model, I'm not an artist, but the model that was brought up early on, I think frankly was deceptive. It appeared to have a very nice green front lawn, not 15 feet away from Bridge Street. It also didn't really portray the driveways, particularly the problematic one on the right or east side rather. In any event, as to the criteria at issue, as to adequacy of site, this is a 23,000 square foot lot in the R40 zone where 60,000 square feet is required for a house and a guest house. Member of the board earlier talking, another hearing talked about 57% shortage in terms of land. We're not even close to being 57% of what we need. This is very, very small. The site is simply not adequate with what's proposed, which includes nearly doubling the footprint and the gross floor area of the main house. Tearing down both structures would have allowed for building a conforming house, but except for the height, neither structure meets street or sideline setbacks. That's because there isn't room for 2 houses on this lot. The site is simply not adequate. As to compatibility of size, the neighborhood has variously sized lots and structures, but no lot this small has this much house. With a combined gross floor area of 5,300 square feet, especially set back only 15 feet from the street. And I'd also suggest to you the gross floor area is actually about 650 square feet more than that, because the, quote, uninhabitable, unquote, basement in the second dwelling would historically have been included in gross floor area. We only don't count crawl spaces. Just because something is 6'6" doesn't mean that people can't spend time down there. As to the extent of increase in nonconformity, this is a severe problem under our bylaw. The westerly setback is currently 24.9 feet, 1/10 of a foot of nonconformity, 1/10 of an inch of a foot from being in compliance. It's going from that nearly compliant to 13 feet from the lot line, only half, slightly more than half of what's required. It's required for good cause, by the way, as you know. That is a significant increase in nonconformity. The scale is not appropriate for the neighborhood. Bridge Street is on the periphery of the old village. Bridge Street is a scenic way, and while Karen has, as usual, done a very nice design, it doesn't belong on this small lot. It is an overburdening of the lot, of the neighborhood, and of the neighbors. You've heard from the abutters close by and elsewhere in the village, and for that matter, elsewhere in town, who live in other parts of our community, who care about Bridge Street and care about preserving its charm, its street, and its appearance. As to impact on traffic flow and safety, the second driveway clearly is an issue. The applicant's attorney pointed out correctly that there are some other houses on Bridge Street with similar driveways. That's true. Just because there are some problematic and difficult driveways on Bridge Street, which you have to back out onto, doesn't mean we should be adding driveways like that to exacerbate the problem. As to noise and litter, you know, we can't base a decision, you can't base a decision on what has been in the past, but it has been a short-term rental, and it may be again. The town has begun to look at dealing with the problems created by the owners of non-resident owners of short-term rentals. I think that is a concern. As you know, the criteria that you were involved, that are set forth in our bylaws say you must consider those, but you're not limited to them. And while I don't always agree with the Historical Commission, I was a little bit concerned by the somewhat dismissive reference earlier on in the presentation found in the Massachusetts, but selective reference to what was in the Massachusetts Historical Commission's form on this property. I don't have time to go into it right now, but it is an older home, probably the oldest on Bridge Street. And I think the letter from our Historical Commission speaks to its disappointment that no thought was given to restoring or preserving a house that is perhaps nearly 300 years old. I recognize that my time is about to expire. In closing, I would simply say you've heard from most of the neighbors in Bridge Street. With one exception, they are unanimous in their opposition. You decide substantial detriment, but I also understand that you recognize, or I recognize that you understand, that neighbors have a particular sensibility to what is detrimental in their neighborhood. And I urge you to reject this petition. Thank you.
Thank you, Attorney Litchfield. Is there anybody else that wishes to speak against or has a specific question? Seeing none, rebuttal.
Sure. Thank you, Madam Chair. To start, I think some of the letters, I don't know if folks may have been looking at prior versions of plans or confused by the plans. There's no third structure on this property proposed. It's the two houses that are on the plan. There's no third bedroom in the guest house that's proposed. It's 2 bedrooms only. So to clear up some of the confusion that may have been raised as part of that, part of those letters. In terms of the doubling in size, I guess for gross floor area, that's true relative to the main house, but I think you have to look at the property as a totality. And when you look at the gross floor area numbers between the two houses from what's there now to what's existing, yes, it's an increase, but I wouldn't say it's an abnormal increase from what this board generally sees. And the gross floor area for the rear structure, the cottage, is actually decreasing, it has been referenced. It was pointed out that it's, you could still use the basement. I suppose that's true. There's only exterior access through a bulkhead, so I think for a traditional finished basement, that's not gonna be too appealing to anyone. And so it really is just gonna be for storage space, for the Benincasas, since they have a garage, but other than that, it'd be nice to have the basement area there for storage in the rear cottage. The rental question, I know that's not really part of your criteria, but I did want to address it because I have talked about this with Steve a couple times, Mr. Benincasa, and he says his plan, and when he bought it, was to ultimately, it would be a house for his family. So he has a house in Chatham. He has 2 grown daughters with families, and so this was a place where they could come and stay. He was attracted to it because it's got 2 structures, so each daughter and the family could have some space, some privacy, and so that's what really attracted Steve and Barbara to this property, was that element, and to use it as a family property. And they're hopeful they'll come and visit. Steve said, well, if I wanted to rent it, they'll be here in July and August all the time anyway, so there's not much time left for rental, period. So again, that's what Steve's expressed to me now is that's the goal for the property, not to do short-term rentals. Just to touch on the streetscape element, again, we're not increasing the size in terms of height. It's actually going down a little bit. It is within the setback, as Mr. Litchfield stated, but I'd say most of those structures along Bridge Street, or at least a large number of them, are within the setback, close to the street. I think that's part of what's charming in that area of town. The house isn't any wider than what's there now, it's just going back. So again, that's gonna hide the additional size of the structure. Karen's using, again, dormers. It's not a gambrel design. I think it's a very traditional design, so that additional mass is really gonna be broken up for the use of the dormers. As Karen mentioned, we have the porch on the front, the covered porch, that's at the current setback to match, so the actual flat part of the house is even further back from that, and I think the porch also helps break up massing, because as you look at it visually, it has that element of breaking up the house as opposed to just looking at a flat wall. You have the porch there. I think part of the problem, it seems like people were unhappy with whatever happened in 2008 and 2009 in terms of the new guest house that's there. Well, new, 15 years old now. Steve and Barbara didn't own it when that happened. They bought it 4 years ago, so they had nothing to do with whatever was built back then. They bought it with the way it is now. And I don't think it's really fair to say, well, you should go back to looking at it like it's a vacant lot, as opposed to comparing what we're proposing today versus what's there now. And I think really the question for the board is, well, if you had this vacant lot, what would you build? That's not the question. Is what we're proposing substantially more detrimental than what's there now? And there are 2 houses there now. And that's what Steve's trying to keep. And for family reasons, 2 houses are important to him. And I think the design, the location, especially the scale of the cottage, is a real improvement. And I think visually, once constructed with Karen's design, I think folks are going to find the visual character has actually improved quite a bit at the property. It's been a long night, so end there and happy to answer any questions.
Thank you very much. Questions from the board? Steve? Yep.
Well, my first question, you've sort of already touched on it a bit. I was going to ask why 2 houses, and you sort of explained that already, so I won't ask that question. The thing that sort of jumps out at me in one of these letters, I think it's from the Historic Commission, is that you were before them at least twice for this house, and they first gave a 6-month delay, demolition delay, and back in 2022, and then again an 18-month demolition delay in 2023. What has been done has there been any consideration to restoring that house? Because I walked around it, the foundation is a little rough, but the house can certainly be saved, and I don't see in the period of time that was allotted, it doesn't look like any consideration has been given to restoring that house.
They've had, after they purchased, there was engineering reports they had about the condition, as you mentioned, the foundation. Steve and Barbara initially looked at it, but the determination in their mind was made that salvaging the existing house wasn't feasible for them. And so since the demo delay, they have not gone back and looked at it further. They did initially consider that option. That would have been perhaps preferred on a lot of levels in terms of cost and everything else, but since the initial demo delay has been imposed, there's been no additional review of that.
Okay. And also, the plans that we're looking at, I think, are from 2023, so there's been no effort to change anything, it doesn't look like, for 2 years that you had, to maybe make it more compatible with the neighborhood, maybe eliminate one of the houses.
Well, I think so, that's a little bit of the history, because there was no hearing in 2023 that ever took place. It was the 2022 hearing which were different plans. It was a bigger guest house, it was a higher main house. Plans were drawn, they were gonna go back in 2023, and then the demolition delay was imposed, so my clients made the determination they were just gonna hold off and then file. So those plans, again, are different than what were initially proposed to this board, which might be a little bit confusing with the dates. I'd also point out that there was initially gonna be a garage that was gonna be installed in between the two houses, and that was removed as part of this most recent application.
Okay. And then, it's very minor, but, I kind of look at things like this. On page A1, where it shows the front elevation of the house, the front door is missing.
I sent Sarah some revised plans that do show the front door there.
Okay.
But it's on the plan.
Okay.
Sorry about that.
We need that, yeah.
Yep. Any other questions, Steve? No? Okay, great. Paul, questions?
I guess my question is, when I'm looking at the grid that you provided, Jamie, and that is that when you compare the 2025 proposal to the 2022 proposal, I think there's a substantial benefit there in terms of the differences that you've done. But when you look at the existing, like gross floor area at 322 Bridge Street is 2108 square feet and would now be 4,022 square feet. And the gross floor area at 324 Bridge Street goes from 1304 to, that's 1290, is that correct?
That's correct.
Okay. So the big increase here is on the gross floor area on 322 Bridge Street, and the finished living area on 322 Bridge Street goes up by 1161 approximately. Is that correct? Am I reading that correctly? Yep. Okay. And your solution, as I understand it, you need a second egress on the main house, and that's the reason for the deck?
Correct. It's also to give them some outside space, because right now there's a patio on that side of the house, but it's at the lower level, which was the original first floor plan.
Is there any other solution to the second egress, other than to go into the setback area on the west?
Well, we can't do it on the east because we meet the setbacks, so we have a conforming setback on that side. We didn't want to put it at the rear of the house because that would push the cottage back even further, and we're trying to maintain that backyard. That was something important for the abutters. It just makes most sense on the right side because that's where the existing patio has always been. So they've always had outside space there. So we're just trying to reclaim that. It's at the Bridge Street elevation, so it's not towering over the abutter.
That gets you into the whole issue of it being a small site, and in effect, you're trying to fit 5 pounds into a 3-pound box, basically, right? Okay. And the solution with respect to the basement is a 6-foot 6-inch ceiling, so it's not code and therefore not likely to be used at all.
Correct, just storage. As I said, it only has a bulkhead access from the exterior.
Okay. I have no other questions.
All right. Dave Veach, questions?
No, I have no questions.
No? Okay. Ed?
Yeah, I guess my one question is regarding the deck also. There's an existing patio there. It looks about the same size as what the deck is there. I guess that could be a patio, but if it's a patio, you could encroach it all the way to the lot line. So you're actually, with the deck, it's actually a little bit smaller than
Right.
than you'd actually do with a
The
patio.
patio would be down a floor, and I wouldn't be able to have egress for
Oh, how many?
the first floor.
Okay. How much lower is that?
The existing patio from
Yeah.
the deck?
Yeah.
I would say it's about 10 feet.
Oh, it's that, okay, it's that dramatic. Okay, thank you.
David Nixon, questions?
Yeah, I just had two, and it had to do with two concerns that I have, and it was in the myriad of letters. The two issues came up a little bit. Number one is the parking spaces on the street. I think that needs to be eliminated. And it's not appropriate to add another one along Bridge Street. It just isn't. So I think I would suggest to you that that needs to be done. And secondly, the deck, I've never been in favor of having an encroachment that is increased when particularly you don't have people next to you that are in favor of it. So I hear what you say, Karen, about, providing some sort of couldn't you fill that area and put a stone patio? And that would eliminate the need for a structure.
That could be done.
I-
So
you
have
know.
an elevated patio.
Yeah, so that way you wouldn't encroach upon them. It would be 25 feet, which is correct. And I would think that would satisfy certain issues that we've heard. And I don't think you need extra permission to fill that land in and build that deck. So those would be my two, more than suggestions. They're my two needs. We'll leave it at that.
Okay, Lee, did I already call on you? No, go ahead.
No questions.
Jay, please.
I just want to mention, it looks like, the egress at the deck would be a third means of egress because there's one on the lower level. So, I think that would satisfy. You'd get one on the front elevation near the street and then one on the lower level. So the one off the deck would be a third means of egress.
So that works? Yeah.
Good.
Good, very good. Virginia Fenwick.
So Jay, are you saying you wouldn't need that third one?
You only need two means of
Okay.
egress.
Yeah, I had a question also about I thought you said, Karen, the height of the deck off the ground was street level, but I must have misheard you.
The new one?
Yeah.
Yeah, if you look at the model, you can see that the deck is the same level as that parking space in
Okay,
the
so
front.
there is that drop down, okay.
On the back, there's a drop down. On the
lot,
front, it's, because the lot slopes down.
So even if you had to have that as your second egress, which it sounds like you don't, couldn't you just have a little staircase coming down from the side? You don't need that whole large deck for egress purposes, right?
No, but it does give them some outside enjoyable space.
Karen, I think you also said that you pulled the original plan. One of the original ones was to have the guest house way farther back in the yard, and you've pulled it back at the accommodation or request or feedback of the two east and west abutters, right?
Correct.
Okay. I thought that's what I heard you say. Yeah, parking pad on the front, I don't really have a question about that, but I did have a concern about that, and Dave Nixon covered that. One question, final question. So the historic nature of the house, and there's been a lot of feedback about that. Would you allow like a Protect Our Past or a similar organization to have access to see what they could salvage as part of saving some of the history of that really special home?
Yeah, Steve has no problem with that.
Okay. All right, that is all I had, thank you.
And Lee, did you have a question? I forget. No, you don't. And I would also agree with Mr. Nixon. My question is, can you do without that deck? And it would be a condition for me to approve it, so just something to think about. And also the parking pad idea.
Yep.
Yeah, and, you were up against a lot of letters, but they weren't all, do you agree that they weren't all accurate in their allegations?
Yes, I would say some of them were based on prior versions of the plans, it seemed.
Right,
To me, from
right.
reading them.
And we also can't regulate what people do with their private property.
Right.
So, yeah. All right, so with
Can I
that,
make one more statement about that
Sure.
patio that was just suggested. Thinking about it now, looking at it, there would have to be a retaining wall, obviously, around it, which would be in the setback on the right-hand side, and you're only allowed to have a 3-foot-high retaining wall in the setback. So we would need permission to do that if we made it a patio.
Please.
It would be a 3-foot outward-facing retaining wall, and I think you'd have an inward-facing retaining wall, wouldn't you?
It would be holding the deck up.
Well, I was thinking you could probably leave that stairway that you have going out where the deck is now, reposition the door and have the patio at the bottom of those stairs, maybe.
Right. I think one option mentioned was to raise the patio, fill it
Yeah.
in and raise it.
Okay, so if you're doing an outward-facing retaining wall, then yes, 3 foot would be the maximum.
Right,
Otherwise, it would have to meet setback, which it couldn't do.
correct.
Okay, so that's all doable? And,
No.
no, not doable.
Well, I
minute.
just spoke to Mr. Benincasa, and he's okay with removing the deck and removing the
Okay, that's
parking
even
pad.
better.
And it sounds like from what Jay said, we do not need that for access.
Be quiet.
Yep,
You don't want to hear from him.
well, we're still in an open, you know. Okay. Go ahead, Counsel, anything else?
No, that's it.
So you agree that, my question is, would you agree to remove the patio, I mean, the deck?
The deck and the parking pad. yeah.
Right, yes, oh, that's even better.
Yep.
Okay, so with that, Paul? No?
One question.
Yes,
Sorry, Jamie, one question. So removing the deck and the patio on the west side, because in the decision, I do still need to be able to reference if there's any nonconformity. You are going to, can you provide what the proposed distance from the westerly abutter will be?
I believe it's 25.4. Let me just double check that. 25.4 is what Dave, it's not on the plan, but when I asked
Right.
Dave Clark, that's.
Yeah, I will need a new plan from Dave Clark showing those changes.
Yep.
Thank you.
and we didn't approve it yet, so,
No.
you know, we did not. Mr. Nixon, did you have any?
I was going to say, and that plan needs to be submitted to Sarah tomorrow morning before 8:30, please.
We know what we're doing
But
tonight.
but again, we have not made a decision yet. So, Paul now.
I'll move to close the hearing and move into deliberations.
Steve Veach seconds and votes yes.
Yes.
All vote yes?
Ginny votes yes.
As do I. Okay, now we'll do deliberations. Ed?
Well, I like the plan. I particularly like the front porch, and perhaps that's an opportunity for the Vinicasas to make friends with all their neighbors. I think the plan reduces the building height. They're reducing some of the pre-existing nonconformities. As far as short-term rental, that's not really under our purview. And then you also have the condensers being, moved back out of the setback. So I like the plan. It's, how the two buildings originally got there, I don't know, and, but they are there, and they're pre-existing non-conforming, so, they can work with that, so. I would, if I was voting, I'm not, I would approve the plan.
All right, Mr. Veach?
Yeah, excuse me. I was a little surprised at the letters, honestly. And there was a lot of things in the letters that were not accurate. And I'm not sure how it came about. Because my first take on, before I saw it in the letters, was looking at the plan and thinking about what they had originally proposed, or back in 22 or whatever. And I think that they responded to at least any of the concerns I had quite well. And I think that they've responded, and I very much agree, as Jamie has pointed out, a lot of the letters were sort of framing this as if it didn't exist the way that it was, the way that it is. And we need to compare this proposal with what's there. And in every respect that I can see, they've made improvements over what's there, with perhaps the exception of the proposed and now deck that's not going to be there. I'm glad we came up with some kind of a solution that's gonna work. I was a little bit, the neighbors and the neighbors on that side, it's in their right to object to it, and they did, and I think that it's not appropriate for us to say, no, you can't do that. At the same time, when I look at the situation on the ground, there's a big tree there that says driveway and everything else. I don't think that the deck was really gonna disturb a lot of people, but that's all right. I'm happy that we came to that solution. And I also agree, and as far as use or potential use, and then I'm a little baffled because I don't actually know the history or anything, but I've been looking at that house that's there, and with the characterization of it being an old house and all that, I imagine it is, the brick foundation is shot, that's for sure. And I doubt that there's much left there, and maybe Pop can come in, salvage some timbers or something. But all in all, to me, this looks like a good example of starting from scratch and actually improving what's there. The design has been informed by the old building and by the location. I think it's really well done, and I'm happy to support it.
Mr. Nixon?
Well, as has been mentioned by you, Jamie, and Dave, and also Eddie, our job is to compare what's there with what you want to do. And is this new home, which is both buildings have been lowered. Certainly the guest house has been improved hugely as far as the placement of it, where it goes. I like the idea of incorporating the garage in the front building and all that. The plan for the house is really attractive, and I think Eddie mentioned it, just the front porch. I mean, just the front porch by itself makes it look so much better. And as happens, particularly in a scenario like this, what goes on behind this house is going to blend away. You're going to drive by, you're going to see it, particularly with the foliage and all that kind of stuff. So I really think you did a heck of a job. You really did. And I'm more than happy with the two small conditions we described to support it.
And Paul?
Yes, I agree that this is certainly a tremendous improvement from what was brought to us in 2022. And I think it's going to be an improvement over what's there now, which is really our standard. I mean, I agree that I wouldn't have wanted to put two houses on there in the first place, and that the lot is too small for that, but that's what we're dealing with, and we're trying to come up with a solution that will somehow comply with our overall standards, which is, would the new house end up being substantially more detrimental to the neighborhood? And I don't think it would, so I think for those reasons I would support it.
And Lee?
Yep, I agree with my colleagues. It's definitely an improvement from what's there right now. As others have said, who knows how that happened, but it did. So I agree, the design is very attractive. I think it's gonna, although it is a small lot, it's still a lot of houses on that lot, but I think it will be fine and not substantially more detrimental.
And Steve?
Well, I guess I'm the odd man out so far, but I don't like this project at all. I think the lot is vastly undersized to support two houses. I think if you're gonna, there was no effort in over two different time periods, 6 months and 18 months, 24 months total, to try to do something with the house that's there, or find a solution, or find somebody that can move it. So there's been no effort into trying to maintain that house. I think the house in the back is a safety issue, not only for the people who might park back there and then want to get out, but for first responders, getting an ambulance down there or a fire truck in the back, and if there's 6 or 7 cars in the parking lot, and now if they're losing that parking pad, there's potentially even more cars in that driveway. I think it's a safety issue, and for those reasons, I couldn't support this.
Okay, Virginia Fenwick.
Jamie, I want to start off with my appreciation of your supplemental summary that you gave us in advance of the meeting, because there's a lot going on with all of this. There's a lot here. We've had multiple years, we've had a couple plans, and that was very helpful as opposed to just absorbing everything at the hearing. So thank you for that. When I look at what, comparing and I do agree there were some inaccuracies in some of the correspondence, and I think it's because of the multiple things that are going on here in the different versions of the plan. But when I go through, I believe if you eliminate the deck, then you're keeping the western abutter setback. So that's an improvement. You would be improving the western abutter. It looks like you're improving the western abutter and improving the problem with the second home exceeding the gross floor area. So I think if you eliminate that deck, you are not creating these, not exacerbating any of the nonconformities. In fact, you've improved everything, right? I mean, if
He's
I've
not going
kept.
to be able to respond because it's.
Oh, okay.
Closed.
It looks to me like everything, if the deck is taken off, is an improvement or staying the same. It's not going to go to conforming, obviously, which goes to the point of, I think, Jamie's closing arguments about that. This is what's there now. This is, I hate to see an antique home go away. But I think what Karen has proposed is very respectful of the original architecture. I agree, I think it's well done. We can't save every home in Chatham. If we can preserve some of the features, that would be great. So I think if you X the deck and you eliminate that parking in the front, which I would also agree I'd want to request that. I don't think it's more substantially detrimental than what's there now.
And nor do I. And I agree with all my colleagues that have said positive things. And I also, one thing stands out to me that the Historic Commission said that they looked at this property as what is it, by neglect? Demolition by neglect. And so if you think about demolition by neglect, and then you see this beautiful design that you've just come up with that actually doesn't have any increased nonconformities, how could you ever think of this as substantially more detrimental? It's almost, you can't get there from here. So it's unfortunate that it's demolition by neglect, and this is no fault of the current owners at all. This is what he found, this is what he wants to do to it. I think at the end of the day, the neighbors are gonna be very happy with this, and I'll turn it over to Paul for a motion.
I will move to approve the application as submitted with some additional conditions. First, that all construction activity and vehicles to be contained on site or at a neighboring property with the permission of the property owner. That secondly, between June 30th and Labor Day, there'd be no exterior construction allowed. That no work would be permitted on weekends, and construction activity would be between 8 a.m. and 5 p.m. only. And thirdly, that the proposed deck towards the western boundary line be eliminated from the proposal. And fourth, that the proposed parking off of Bridge Street in front of the house be eliminated.
David seconds and votes yes.
I vote yes.
Paul votes yes.
Jenny votes yes.
As do I, it's unanimous. Congratulations.
Thank you very much.
And thank you, and good luck. All right, it's 7:20, and we have one more, probably short, application, 24-154, Robert and Mary Bainbridge. 112 Inlet Road with Attorney Litchfield, who knows what to do and how to do it at this time. I figured quadruple.
Application number 24-154, Robert and Mary Bainbridge, care of William G. Litchfield Esquire, 330 Orleans Road, North Chatham, Mass. 02650. Owner of property located at 112 Inlet Road, also shown on the Town of Chatham's Assessor's Map 14B, Block 23, Lot C13. The applicant seeks to enlarge, extend, or change a non-conforming dwelling in a non-conforming lot via the demolition of the existing garage, reconfiguration of a deck, and construction of additions. The proposed additions will comply with all bulk and dimensional requirements of the bylaw, but is considered a substantial alteration, and under the second except clause of Section 6 of Chapter 40A, such substantial alteration requires the grant of a special permit. The existing building coverage is 2,992 square feet, 8.9%, and the proposed building coverage is 3,328 square feet, 9.9%, where 10% is the maximum allowed. The lot is non-conforming in that it contains 33,900 square feet, where 40,000 square feet is required in the R40 zoning district. A special permit is required under Mass General Law, Chapter 40A, Section 6, and Section 5B of the bylaw.
Welcome back, Mr. Litchfield.
Good evening, and thank you. I represent Bob and Mary Bainbridge. Any questions?
No?
I move that we vote yes.
In fairness to Mike Tartamella of Patrick Arn Architects, he's been with us for 3.5 hours. I know you have knowledge of what Mike's firm does, and I know you've been to the site. Certainly, I would be happy to go through the criteria. I don't mean to steal Mike's thunder, but I think you're familiar with the property.
Yeah, okay, sounds good. Is there anybody here on Microsoft Teams who wishes to speak in favor of this application? If so, please raise your hand. I do not see anybody anywhere at all, so I will read the correspondence as there are 3. Let's see. On 2/24/25, Judith Giorgio tells us that this is calling for a 6-dwelling bedroom, and it was approved for 5 when the septic system was installed in 2006. They've been ordered to connect to the sewer, and they may add their 6th bedroom. Final approval will be conditioned on sewer connection. Then we have a note from the Conservation Commission. They say that they don't even need to come there, basically. The work does not require filing of a notice of intent, and it meets the performance standards, and that was given to us on February 6, 2025. And then we have another letter from Eunice Burley, and she lives on, looks like 170 Inlet Road. She's writing in favor. She totally approves the proposed work. That concludes our correspondences. Is there anybody that wants to speak against or has a specific question? I don't see anybody anywhere, as I said. So now, are there any questions from the board? I don't see any of those either. Paul?
I'll move to close the hearing and move into deliberations.
Dave Veach seconds and votes yes.
Vote yes?
All vote yes.
Ginny votes yes.
As do I. Okay, deliberations. David Nixon, say it for us.
This is in no way substantially more detrimental. It hits all our criteria, and we should approve it.
Okay? Mr. Veach?
I totally agree. And very nice-looking project. A great location, geez, what a view from there. Oh, the view is spectacular.
All right.
It's nice, yeah.
Ed, you concur?
I concur, and let's save the owner a few bucks and close this hearing.
All right. And Paul?
I agree.
Lee?
I agree.
Steve?
I agree.
And Ginny?
Beautiful. I
As
agree.
do I. Okay, Paul?
I'll move to approve the application as submitted. I guess the question is there any need for these conditions? I don't think, given the backside of the hill there and so forth, I don't think I see a need for any conditions. So I'm going to move to approve the application as submitted.
Dave Veach seconds and votes yes.
I vote yes.
All vote yes.
Ginny?
Ginny votes yes.
As do I. It's unanimous. Congratulations.
Thank you very much.
Thank you for your
Mike, my
consideration.
apologies.
And now we need a
I'm
motion.
sorry, I was not there in person. I'm usually
Motion
like
to
to be there in
adjourn.
person. I was-
Somebody.
I'll move to adjourn.
Dave Veach seconds and votes yes.
David Nixon? Oh,
Ed votes yes.
We all vote to adjourn, yes.
I vote yes.
All vote yes?
I vote yes.
Steve votes yes.
Ginny votes yes.
As do I. It's unanimous, and what time is it?
7:24 PM.
All right, good night, Chatham.